This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed. This is the Northern Ireland Assembly Plenary Programme Signed.
first item in the order paper is the consideration of executive business not concluded on Tuesday the 1st of March. However, thankfully all business was disposed of last night, so we can move on. The next item of business is the consideration stage of the Defamation Bill, and I call Mike Nesbitt to move the motion.
Thank you, Deputy Speaker. I beg to move that the consideration stage of the Defamation Bill be heard.
Members will have a copy of the marshalled list of amendments detailing the order for consideration. The amendments have been grouped for debate in the provisional grouping of amendments selected list. There is a single group of amendments which contains the 15 amendments and opposition to clauses 1, 5 and 11 stand part that deal with the regulations, clarifications, review and commencement. I would remind members intending to speak that during the debate on the single group of amendments, that they should address all the amendments on which they wish to comment. Once the debate on the group is completed, any further amendments in the group will be moved formally as we go through the bill, and the question on each will be put without further debate. The question on stand part will be taken at appropriate points in the bill, and if that's clear, we will proceed. We now come to the single group of amendments for debate. With Amendment 1, it will be convenient to debate Amendments 2 to 15, and opposition to clauses 1, 5 and 11 stand part. And I call the Deputy Chairperson of the Committee for Finance, Keith Buchanan, to address his opposition to clause 1 on behalf of the committee, and to address the other oppositions to clause stand part and the amendments in the group. Mr. Buchanan.
Thank you, Mr. Deputy Speaker. I would like to thank the sponsor of the bill for the related oral briefings and written information which he provided to the Committee for Finance during the committee stage of the bill. I would also like to thank the Minister for the oral and written briefings information which the Department provided to the Committee during their journey. Mr. Deputy Speaker, with your indulgence, I will make a few very short general remarks on the bill and on the committee stage. The bill itself is a little unusual in that it replicates almost exactly the provisions of the England and Wales legislation from 2013. It covers important, evolving and complex matters like free speech, a free press, the access of social media commentary and the protection of reputation. The committee stage for the Defamation Bill began on the 14th of September 2021. Around 23 organisations and individuals responded to the committee's call for evidence. 9 oral evidence sessions were undertaken. It should be noted that there were a number of very well-informed stakeholders, some of whom enthusiastically contributed to the committee stage and some of whom, for various reasons, would only provide limited written submissions. It is also notable that there was an absence of cooperation between the Department and the bill sponsor. This became problematic at various stages and various points during the committee stage. It is hoped that this will not become the norm for private members' bills going forward. Finally, the committee stage had to be conducted on a short and less than optimal timescale. I understand that in respect of this last point, other committees were in a similar position. I understand that the Committee on Procedures may comment on this shortly. Consequently, I will say no more about the scheduling of PMBs and statutory committees' end-of-mandate work programmes. Mr. Deputy Speaker, I won't take the House through the detail of the committee's report. I will instead just pick out a few of the relevant key issues. The first of these is the serious harm test. The bill seeks to replicate the provisions in England and Wales which would require a defamation action to show that serious harm was caused or was likely to be caused to the reputation of the claimant. A number of respondents to the call for evidence strongly argued that this provision was absolutely essential. They suggested that the requirement to demonstrate serious harm would dissuade people and organisations with considerable means at their disposal from beginning speculative defamation actions against public interest journalism. They contended that this was a largely unreported, though surprisingly common practice in Northern Ireland. Examples were even provided which appeared to illustrate that those with the wherewithal to access skilful lawyers could easily exploit existing legal provisions in Northern Ireland. It was claimed that this was in order to intimidate local news outlets into either not publishing damaging material or withdrawing such publications and paying excessive punitive damages. It was agreed that this had a significant chilling effect on normal public interest reporting in Northern Ireland. This was linked to the practice of bringing so-called strategic lawsuits against public participation. However, it was also contended by other witnesses that the so-called intimidation of media outlets by wealthy individuals and their lawyers was not at all common, and that such interactions were in any case correctly controlled and subject to the proper governance of a published and agreed defamation protocol, which is currently being revised. It was contended that journalists could always take advantage of the common law rule that truth was a defence against an action for defamation. It was argued that if journalists simply worked to appropriate standards of accuracy and adopted a fair approach to the reporting of public interest matters, there could be no chilling effect for local media. The bill sponsor also contended that the serious harm test would require an early decision by the court in respect of merits of a defamation action. It was suggested that this would reduce, or at least front-load, the cost of defamation actions, thus providing access to the courts for ordinary people with limited means in order to allow them to seek protection for their reputation or to seek appropriate redress. Others argued that the serious harm test had not reduced cost in England and Wales, and that the front-loading of cost was of no benefit whatsoever to ordinary people undertaking defamation actions. They contended that the requirement to prove serious harm would actively dissuade ordinary people from protecting their reputations in court from what might be termed lesser slanders, particularly if they were faced with media organisations and/or internet providers with considerable financial means. The committee supported an amendment which would require the department to review the jurisdiction of the county court. It was argued that as solicitors, rather than barristers, can represent their clients in these courts, the cost would be lower and justice more accessible for ordinary people. However, that amendment was not put down for debate today, as related work is ongoing at the Department of Justice. As with all of the important clauses of this bill, the committee felt that it had only limited time to both consider the ramifications of the provisions and explore the significant differences of opinion. Some members contended that the absence of consistency with the rest of the UK in respect of defamation legislation, and in particular the serious harm test, was difficult to justify. They felt that Northern Ireland's legislative framework in respect of defamation was being exploited by those with means, and that reform was urgently required to protect public interest journalism. Others argued that the consequences of the relevant legislation in other jurisdictions of the UK or elsewhere was either not yet fully understood or was subject to a considerable level of debate. Still others argued that the serious harm test may in fact be harmful and would limit, not enhance, access to justice for those with restricted means and who find themselves defamed. The committee divided and indicated its formal opposition to Clause 1 standing part of the bill. Mr Deputy Speaker, moving on to Clause 3, honest opinion, amendments were proposed clarifying reasonable belief. These were aimed at the needs of the mass of social media commentators who might reasonably rely on statements of supposed fact made by professional journalists and broadcasters in making their own comments. Most members felt that the suggested amendments were straightforward and provided additional and necessary clarity in respect of determining a reasonable belief that might underpin an honest opinion. Other members were less sure about the interpretation of the wording, which referred to facts that might reasonably be believed to exist at the time of publication. The committee therefore divided on the amendment and agreed that it should stand part of the bill. However, some of what was proposed has not been put down for debate. Perhaps in his response the bill sponsor may clarify on this point. Mr Deputy Speaker, I turn now to Clause 5, operators of websites. This clause creates a new defence for the operators of websites where a defamation action is brought against them in respect of a statement posted on the website. The defence applies if the operator can show that they did not post the statement, but there are related conditions. The bill sponsor contended that the clause was designed to support locally managed websites, such as the online versions of some local newspapers. He argued that moderating all user-generated content would require resources and funding of a scale that would discourage opening these platforms to the public, thus curtailing free speech. He contended that the clause would ensure that anyone who was defamed by user-generated content in this way would have the opportunity to identify the source of the defamation so that legal action could be initiated. A number of respondents expressed considerable opposition to this clause. They argued that, as drafted, it would provide an exemption or very significant limitation of liability to internet intermediaries or operators of websites. It was contended that it was not at all clear how operators of websites is to be defined, and this defence would be used by social media networks who not only host content but also control it and permit mass publication. The exemption/limitation provided in the clause was described as being unjustifiable and far beyond the defences under European Union e-commerce regulations. Other stakeholders referred to a significant increase in actions against social media platforms for defamation in the last number of years. This was described as a testament to the lack of regulation in this area. These stakeholders called for more legislation to regulate media operations, which should apply to all forms of media, including social media, and not just mainstream outlets. The Department advised that it is awaiting the findings of a related view in the Republic of Ireland and believed that any amendments around social media regulation could be beyond the scope of the bill and the competence of the Assembly. The Committee expressed considerable reservations about this clause. Members referred to multiple examples of very serious defamations on social media sites which were by anonymous individuals or so-called straw men who would often easily evade court action. Members indicated significant dissatisfaction at the inability or unwillingness of large-scale social media operators to address this grave problem. The Committee recognised that extensive reform was required of these matters and that this would be better undertaken at national level through the new Westminster online safety legislation or even at pan-national level through the international agreements. The Committee also felt that these matters might be usefully further explored by the Department in its ongoing consideration of defamation legislation. The Committee recognised the sincerity of the bill sponsors' wish to provide access to free media speech for local news outlets and agreed that action would be needed in order to protect local newspapers from unfair competition from other providers who do not face the same legal exposure in respect of defamation. However, the majority of members did not feel that this bill was the appropriate vehicle for such measures. Further to the above, the Committee also noted the very real possibility of conflict between the clause and the anticipated Westminster legislation on online safety. The Committee noted also the possibility of conflict between the regulation making power in subclause 5.5, which would require the identification of the posters of allegedly defamatory material, and Article 8 of the European Convention on Human Rights, which refers to the right to a private life. Given that the clause may have unintended consequences of further reducing the ability of social media operators and the urgent need for a better and more robust vehicle for reform in this area, the Committee divided and agreed that the clause as amended should not stand part of the bill. I understand that the bill sponsor may well be in the same opinion at this stage. Mr Deputy Speaker, I will now address Clause 8, Single Publication Rule. The clause introduces a single publication rule to prevent an action being brought in relation to publication of the same material by the same publisher after a one-year limitation period from the date of the first publication. This replaces what is understood to be what is now a unique Northern Ireland principle that each publication of defamatory material gives rise to a separate cause of action, the so-called multiple publication rule. The Committee noted that the effect of the current arrangements in Northern Ireland is that claimants could make repeated claims for defamation for libels which are, e.g., republished on the Internet perhaps years after the original publication date. On one hand, it appeared that such a provision, which seems to be unique in the UK, might be an inducement for libel tourism. It should be noted, however, that no evidence that Northern Ireland is a centre for libel tourism was provided during the Committee stage. On the other hand, it seemed that the existing provision could motivate website operators to remove current and historic libellous material from their platforms more regularly and with greater diligence. The Committee also noted that it might be argued that in the absence of effective international agreements on removing historical material from the Internet, the current local legislation could have an equivalent positive effect. The Committee felt that, as with Clause 5, issues in respect of the retention and republication of libels on the Internet might be usefully further explored by the Department. In its ongoing consideration of defamation legislation and related developments in the Republic of Ireland, the Committee divided but could not agree that the clause should stand part of the bill. Mr Deputy Speaker, I will now refer to Clause 9, Action against a person not domiciled in the UK or a Member State. This clause aims to address the issue of libel tourism and provides that a court does not have jurisdiction to hear and determine an action unless it is satisfied that, of all places in which the statement complained of has been published, Northern Ireland is clearly the most appropriate place in which to bring an action. Mr Allister and the Department contended that this might present an additional hurdle for someone to take an action against a person not domiciled in the UK. The bill sponsor indicated that although he could provide no evidence of libel tourism, he felt that the clause was necessary in order to provide protections for individuals who are subject to slanders, etc., which were published about them in this jurisdiction but which originate elsewhere. The bill sponsor brought forward an amendment relating to a typographical error in the bill which wrongly identified the UK as another member state of the EU. The amendment also limited the application of the provision to the UK rather than to the member states of the European Union and states which are a contrary party to the Lugano Convention. The committee divided and agreed that the clause as amended should stand part of the bill. Mr Deputy Speaker, Clause 10 is described as limiting the circumstances in which an action for defamation can be brought against someone who is not the primary publisher of an alleged defamatory statement. The bill's sponsor brought amendments to the committee which would provide a clear definition of the author, editor and publisher. However, these two have not been put down for debate today. The committee noted evidence which suggested that under current legislation and certain circumstances it is possible for, e.g., bookshops who sell defamatory material in Northern Ireland to be prosecuted for defamation, even though this is not the case in other jurisdictions of the UK. Members expressed differing views on the clause. Some felt that the existing provisions of the Defamation Act 1996, which require defendants who are not the author, etc., to take reasonable care, provide sufficient protection for and place a reasonable onus on defendants. These members argued that the clause and amendment was therefore not required. Other members contended that the clause and the amendment clarified the legislation, brought it into line with the rest of the UK and would serve to support publication and public interest. The committee divided on the amendment and supported its addition to the clause. The committee then divided on the amended clause but could not agree that it should stand part of the bill. Mr Deputy Speaker, I will now move on to Clause 11, trial to be without a jury. This clause removes the presumption in favour of jury trial in defamation cases. The result of the clause would be that defamation cases would be tried without a jury unless a court otherwise orders. It is understood that the judge would retain discretion to order a jury trial if they consider this to be appropriate. The bill sponsor argued that no other UK jurisdiction has the presumption in favour of trial by jury for defamation cases. He contended that the clause does not put any bar on the trial by jury, rather it simply removes the presumption. He argued that a judge-only trial will allow for an early definition of single meaning to the words under dispute, and consequently an opportunity for earlier resolution. He indicated that this provision was central to the intent of the bill, which was to reduce the cost and the level of jeopardy associated with defamation actions. He argued that this was key to eliminating the chilling effect on free speech and public interest journalism in this jurisdiction. Some members strongly felt that Clause 11 tended to undermine the important principle that jury trials are the reliable foundation of the UK justice system. They felt that if public interest journalists adhered to good standards and, crucially, ensured accuracy in their reporting, there would be limited danger of speculative defamation actions. The reported chilling effect, they contended, was in respect of poor quality journalism, and some very basic precautions would nullify any such supposed effect. Other members argued that the clause brings this jurisdiction into line with the rest of the United Kingdom and thus certainly does not undermine the general principle of jury trials. They contended that the clause was an important element in the range of measures covered by the bill, which would protect free speech and public interest journalism from speculative defamation actions. Mr Deputy Speaker, the committee also noted that the Gillen Review of Civil Justice 2017 considered matters relating to the defamation and suggested that judges might be given discretionary powers to compel parties to undertake alternative dispute resolutions or ADRs, or face possible financial penalties in the event that formal proceedings go against them. Witnesses to the committee stage also argued that a presumption in favour of the use of ADRs with associated penalties would limit costs and jeopardy and thus have a similar positive effect to judge-only trials in respect of public interest journalism. Mr Deputy Speaker, the committee couldn't help but notice that if the intention of the bill was to reduce the length of legal proceedings and thereby costs and jeopardy, much of this might be achieved. Including a requirement for pre-trial hearings at which the meaning of the words disputed may be determined, enhancing the jurisdiction of the county court in respect of defamation, and enhancing judicial discretion in respect of a requirement for parties to use ADRs or face financial penalties if the judgment goes against them. The committee noted with regret, as it is in the process of developing a revised defamation protocol, the Shadow Civil Justice Council was unable to comment in detail on the provisions of the bill. It was also noted subsequently that the Department of Justice is also in the middle of working up some related measures. Consequently, the committee felt that it could not comment authoritatively on these alternative suggestions. The committee did agree that the Department of Finance should take forward the above as part of its consideration of related matters. The committee also agreed to support the bill sponsor's amendment in respect of judicial discretion on the use of ADRs. However, I suspect for the reasons I have just set out, this amendment was also not put down for debate. Following a division, the committee agreed that Clause 11 on the jury trial presumption should not stand part of the bill. Mr. Deputy Speaker, the committee also supported a number of other amendments correcting typographical errors and altering the regulation making powers from negative to draft affirmative resolution. Finally, Mr. Deputy Speaker, the committee considered Clause 18, Commencement. The clause, as drafted, indicated that most of the provisions of the bill would be commenced at the discretion of the Department. The committee felt that this might lead to the Department not commencing those provisions which it felt to be unacceptable for a very considerable period of time. Members noted that this was unwelcome practice and is not uncommon in respect of PMBs and executive legislation. The committee therefore agreed to accept an amendment which would require the Department to commence all provisions within a reasonable time frame. The amendment which is before us today has increased that commencement time frame for most of the provisions from 6 months to a year. I suspect that the committee would likely support such a change. Mr. Deputy Speaker, the committee also agreed to support an amendment which would require the Department to undertake a review of the operation of the legislation on related matters within 2 years of royal assent. Members felt that this is an evolving area and developments in other jurisdictions might usefully inform further legislation. The committee therefore felt that the Department should undertake a review of defamation, and this should include the matters cited above, including serious harm, county court jurisdiction and the use of ADRs, etc. However, this was agreed prior to further related correspondence from the Minister of Justice in respect of her Department's ongoing work on these matters. So, Deputy Speaker, this bill refers to important and complex matters. I think the committee could have done much more with it had we had more time and if stakeholders had been properly informed of the relevant provisions. I'm now going to add some remarks, Deputy Speaker, very brief remarks from my own party's position. Defamation law must balance individual rights to reputation, freedom of expression and effective access to justice. We must draw on and learn from the operation experience of previous reforms enacted in other jurisdictions, not least in England and Wales. It is interesting that the academic report commissioned by the Executive in 2016 found that the case for replicating the serious harm defence in Northern Ireland was less compelling than other provisions. We cannot ignore the fact that the overriding concern among members of the public with current libel law is not whether it restricts free speech in the press, but whether they can get affordable access to the legal system. The defence proposed for website operators does not send the right message at a time when other jurisdictions and legislators are focused on tackling online harms in our society. The single publication rule risks discouraging social media platforms from removing defamatory content in the longer term. One comment from evidence that we heard on the 1st of December, not the 1st of April, I may add, the 1st of December, written evidence, I may add, not verbal, not a slip of the tongue, but written evidence from a journalist. And he quoted, "I hold no brief for liars, but if lies are not causing serious harm, should we not prioritise free speech?" That statement said a lot to me during my time on the committee and during the evidence section, and he ended by saying, perhaps not. Just to sum up very briefly, Mr. Deputy Speaker, we will not be supporting Clause 1, Clause 5 or Clause 8, and obviously then Amendment 4 and Amendment 5 are relevant to those clauses, so we will not be supporting Clause 1, Clause 5, Clause 8 and Amendment 4, Amendment 5. With your indulgence, Mr. Deputy Speaker, I may have to leave the chamber at this point or during the proceedings, but I will monitor exchanges carefully remotely, and I will also return and speak on the wind on behalf of the committee. Thank you, Mr. Deputy Speaker.
I call Melissa McHugh.
I thank the bill's sponsor in particular for bringing forward the amendments which we are debating here today. Defamation law exists to protect people's rights. However, what we often see in defamation cases is a conflict between different rights. That is, the right to protect one's reputation from false statements and the right to freedom of expression. The challenge in legislating in the area of defamation is that the right balance is struck between these competing rights. We want laws that give adequate protection to people when they have been defamed, but we also want laws that don't chill free speech. We have said from the outset that we are in favour of updating our defamation laws. The last substantial uplift on our laws go back to the 1990s. So much has changed since then, especially with the rise in social media and online platforms. However, we have some concerns about this bill in its current form. The bill's sponsor takes the view that our current libel laws are too strong, and he wants to shift the balance away from protecting one's reputation and towards enabling free speech. While some of the clauses are worthy of support, I don't see the need for the fundamental shift towards free speech that the bill's sponsor is trying to achieve. The bill's sponsor has proposed 15 amendments, and we will be supporting all 15. They are largely technical, and they tidy up the wording in some areas. In particular, we welcome Amendment 7, which is a new Clause 14a, which places a statutory duty on the Department of Finance to carry out a review of defamation law within 2 years of granting of royal assent. However, we will be voting against several of the clauses, and I will set out the clauses and the reason. We do not support Clause 1, which is the introduction of a serious harm test. This clause will make it harder for an individual to sue for defamation. Under the current rules, much of the risk already lies with the claimant. There is no legal aid in defamation cases, and the costs of bringing a case are already beyond the reach of many in our society. Clause 1 effectively says that it's okay to make a defamatory statement about someone as long as it doesn't cause them serious harm. It's interesting to note that the main supporters of Clause 1 seem to be media and journalistic organisations. This is not surprising, as Clause 1 will protect their members if they publish lies about members of the public, as long as the lie hasn't caused serious harm. And what is serious harm? That's not exactly clear. What may be serious to me may be not very serious at all by others. Under this bill, it will be for a judge to decide what constitutes serious harm. We are also opposed to Clause 5, which attempts to deal with online platforms. As we know, the vast majority of defamation now occurs online. So, any legislation needs to find a way of dealing with this issue. Today, many of the cases of online defamation involve anonymous accounts, and it can be challenging to find out the identity of the culprit. Clause 5, since its introduction in England, has had virtually no impact, but it also provides a defence to social media companies if they respond to a complaint from the defamed party in accordance with regulations. I was very impressed with Paul Tweed's evidence to the committee on this issue. He described the clause as totally unworkable. Online platforms are not the neutral facilitators of users-generated content that they claim to be.
Gently ask, I appreciate the member giving way, and he and I have spent a long time in the committee. I would just ask gently, would he consider Paul Tweed a neutral adjudicator on our current defamation and libel laws?
Paul Tweed gave evidence to the committee, and I was very impressed by his evidence. In fact, if anything, he reinforced that same point, unlike another journalist who gave evidence to the committee who seemed to think that it was okay If it was only a wee lie they were telling, then that was acceptable. So, as I say, make your own mind up about how you judge Paul Tweed compared to the other journalists who gave evidence at that time. There are other partisan players who have the ability to influence discourse. They have a responsibility to the people who use their platforms, and they have a role to play in the dissemination of false or defamatory material. Now, I agree that a solution is needed, but whether we can find a solution as part of this bill, I am not so sure. I welcome that the bill's sponsor has indicated that he is no longer in favour of Clause 5. We are against Clause 8, which is the single publication rule. This clause would prevent an action being brought in relation to publication of the same material by the same publisher after a one-year limitation period from the date of the first publication of that material. Defamatory statements, particularly if they have been made online, may not come to prominence or to the attention of the injured party for a year or more after the initial publication. This clause would block any case being brought in those circumstances. Clause 10 is very similar to Clause 5 in that it states that anyone who isn't the author, editor or publisher of defamatory material cannot be held liable. This would include online platforms. We are also opposed to Clause 11, which is the move to non-jury trials of defamation cases. The main argument for removing juries is that they are expensive and they drive up the cost of defamation cases, and also that judges alone are better suited to make judgment in these cases. I don't accept these arguments. Juries in defamation cases have effectively been abolished in England since 2013, yet this has not lowered the cost. We are still a less expensive jurisdiction, despite the fact that we have retained juries. I also think juries are far better suited to judge whether the reputation of an individual has been damaged in the eyes of their peers, which is what the essence of being defamed or defamed is. We are happy to support the rest of the clauses, and I will conclude my remarks with this concord.
I call Matthew O'Toole.
Mr. Deputy Speaker, I'm very pleased today to be able to speak on the consideration stage of the Defamation Bill, and I'm pleased that it's got to this stage, and I very much hope that the Defamation Bill completes its passage before and hopefully as intact, as close to intact as it can be, notwithstanding the bill sponsors' amendments today, all of which we support. I should declare at the outset, although we haven't met in the last couple of months, I am the chair of the all-party group on press freedom and media sustainability, and that actually is part of one of the key things that I have brought to consideration of this bill, because it is completely critical as we consider the Defamation Bill that we have legal protections for individuals, all individuals and groups in our society, to be protected from defamatory speech. The question fundamentally we've had to ask ourselves in considering this bill is our current law fit for purpose? And actually it's very difficult to find an interested party who would say that yes, it is. In a sense, the defamation law in Northern Ireland is the most unreformed in these islands, in the jurisdictions that we compare ourselves to, because we share a common basis in the common law, and indeed we have an overlap in terms of the media that we consume, both the rest of the UK and the rest of Ireland, as it were. So it's very difficult to find, other than the odd participant, it's difficult to find an individual who thinks that our current defamation law is working just fine. So I wanted to set out those broad principles before I come on to the detail of the amendments that are before us today. But I also do want to just again mention the precariousness of the position that some of our local media companies and publishers find themselves in, and almost to a person, and we did a call for evidence last year on the state of the local media, Mr. Deputy Speaker, and almost to a group, almost to an editor or a publisher, one of the things they pointed out was that the state of the local defamation law had a chilling effect on their reporting. And not only did it have a chilling effect on their reporting, it had an anxiety-inducing effect on their finances. They have to, because the defamation law is widely perceived to be, and not just perceived to be, held to be by people who know about these things, the more restrictive or the more litigant-friendly, shall we say, in these islands, it places a particular potential financial burden on publishers here. That's not just important because they're businesses and we want them to make profits and employ people, though we do. It's because a free press, a free media, and a one that is viable, sustainable, can fund itself, and also is free to hold people like us to account, is completely critical to the functioning of a democracy. We are, at the minute, all preoccupied with with what's happening in Eastern Europe, where a democracy, like what was a fairly new and nascent democracy over the last quarter of a century, is being invaded, and people are being killed because the bigger bully next door doesn't like the fact that they want to be a democracy. So when we debate these things, we have to put them in a broader context. A free press, a plural, healthy, sometimes controversial press, and we all can name media outlets in this region that annoy us from time to time or all the time, but a free, healthy press is completely critical to the functioning of democracy. Democracy isn't just the technical act of people going to a ballot box and putting in a vote. It is the existence of a healthy discourse, the check and scrutiny on all of us, people in business, people in council chambers, people in courtrooms. So I think it's really important to make that statement as we start this debate, because that's a core and fundamental part of what a healthy and free press is about. And as I said, every publisher, every media company in this region has told us that our current defamation law is one of the things that inhibits their reporting and also creates a level of financial anxiety, because they have to have quite significant levels of insurance in order to protect them from it. I will come on to the amendments. Mr Deputy Speaker, as I said, we're going to support all of the amendments that the bill sponsor has brought forward, and I thank him for keeping the committee abreast of his amendments and his intentions. The Deputy Chair has set out the committee's position comprehensively, and I thank him for that, though he and my party differ on a couple of the clauses. He has set out accurately the breadth of evidence that we took, some of the drawbacks that we had in terms of gathering evidence, and some of the discussions and debates that we had. And one of those debates and divisions is on probably what will be the first division today, which is in Clause 1 of this bill, the serious harm test. The serious harm test is really at the core of the Defamation Act in 2013 that was passed in England and Wales, and forms the core of the law that we, I hope, will be passed here. One of the criticisms that has been made is that, well, there are, I suppose, a number of criticisms, but one of them is that the serious harm test will somehow take from the average Joe or the average Jane the capacity for them to defend their good name, as it were, through the courts. And that is a reasonable question that we had to examine and undertake. And sometimes these are obviously complex and subtle judgments, because in the Committee of Finance, where we're normally debating estimates and budget bills and monitoring rounds, we're having to debate case law and perceptions of litigant behaviour, and sometimes we're doing that from a base of not completely rich evidence. We don't have. I think it would have been better if we had a richer data set of court judgments and outcomes on defamation proceedings over the last decade or two. But we did have pretty rich evidence from a number of parties, academia, and indeed in the campaigners for the free press, the media themselves, and a number of other groups who did point to what is a fairly broad consensus that the balance of the sort of balance of risk, as it were, in our defamation law here is considerably weighed towards litigants. Now, you might say that you might say, well, what's wrong with that? The average person should have a fair degree of the law should favour them when it comes to, as it were, defending their good name. But I come back to the point I made at the beginning. There's a balance on all of these things, and what we've heard consistently from every media organisation is that the balance at the minute is too heavily weighed in favour of the litigant, which has a chilling effect on their reporting, and indeed sometimes can have a financially catastrophic effect on those companies, sometimes in a fairly big way, and those two intersect. Of course, it can be, and indeed the bill sponsor himself from his previous life as a journalist has alluded to some of those examples and given some of his own examples of sitting in meetings where reporting simply didn't happen because an insurer and then a financial controller at a media company would say, this isn't worth the risk. And while I've been, by the way, scrutinising this bill on the Finance Committee, I have heard of another local example, nothing to do with me scrutinising this bill, but a journalist at a local title has told me that their reporting on a very important story was inhibited because of the potential for defamatory action. Now, in that particular case, I won't talk about it. In that particular case, the potential litigant, I think it's fair to say, well, I'm not naming them and I'm not talking about it in any detail, so I don't have to be that careful. I don't think they would have had, even based on our current situation, they should have a particularly strong case. But the truth is that because of the way the law is at the minute and the way it operates, it has been very favourable towards litigants. So we support Clause 1. So we will, and I think the balance of evidence that we got was strongly in favour of supporting Clause 1 as it stands. So we were in the minority verdict on the committee whenever the committee decided to oppose that stand part, but we still support it, and we think it's a core to the bill and to improving our defamation law here. So that was Clause 1. In relation to then, there's a number of technical amendments that the bill sponsor has brought forward, which we'll obviously be supporting. Clause 5, the committee gave its notice that it was going to oppose Clause 5. Clause 5 has been a challenging one, actually, I think for all of us, because the bill sponsor's intention was welcome and understandable, and my party's instinct was to support it. In the end, at committee stage, we abstained on whether it should stand part, waiting to hear more information. Now, to go back to what's the challenge, we all know, and I think we would have unanimity in agreeing here, that the online space has become a wild west in terms not just of horrible, hateful speech, but also often defamatory speech. Sometimes it affects local politicians, and actually in very profound ways. The question really was whether this bill and this clause in this bill was the right means to address that. I understand it's not now going to be moved by the bill sponsor. I understand that. I think we would have had a hard time passing it into law, given all the other unknowns surrounding how Clause 5 would operate. There was a particular concern he had, which I share, which is about potential defamatory content put up by, for the sake of argument, Belfast Live, the newsletter, the Bell Tell, whomever, and them not having the capacity to moderate that, and then being subject to defamation action, and giving them a potential defence, giving them a reasonable defence, and possibly giving the litigant the ability to identify the person. But I think on the balance of evidence that we got, there are very many unknown questions. Obviously, there's an online harms bill or an online safety bill proceeding through Westminster at the minute, which is flawed, but hopefully will make some progress. But there definitely is the need for much more international action. I should say it wouldn't be a speech for me in this chamber if I didn't throw in a little line about Brexit, but of course it would be much preferable if we were able to do that at an EU level. And indeed the digital single market, which is one of the big developments of the European Union over the last decade, Mr. Deputy Speaker, it's one of the reasons why we've all been able to enjoy, hopefully continue to enjoy, we've no guarantees post-Brexit, no roaming charges in the European Union, but the digital single market is also an area which has allowed the European Union to develop its work in terms of regulating online behaviour, and the EU would be an obvious place for us to do that work, but we can't now unless we decide to at a bilateral level. So that's Clause 5. We supported the bill sponsor's intention, but understand and sympathise with the fact that he's not, I understand, but he may say more about himself, going to move it. Amendment 5 is, again, a technical amendment. Amendment 6 is about is a sensible amendment which has been explained to us by the bill sponsor around clarifying the jurisdictions in which actions can be taken, and it's very sensible. Clause 11 was also the subject of some debate and controversy in relation to the bill, and that is the clause which ends the automatic right to jury trial or the relatively automatic right to jury trial in relation to defamation cases. It's important to say, to go back to the Scott Review, we talked a lot about the Scott Review in consideration of the bill, and one of the key things that came out of the Scott Review, which was commissioned by the previous Finance Minister, I believe Mr O'Muller, who himself is obviously understands the publishing world as well, because he's a publisher. One of the things Dr Scott found, and this was emphasised by others, was that the automatically proceeding to jury trial was one of the areas in which, frankly, what happened is that the assumptions were made by lawyers advising media companies that juries are much more likely, whatever the merit of the case, they're much more likely to be litigant-friendly and to award high costs. Let's be blunt about that. That's one of the... and people might say, well, why not? Someone has been defamed. In many cases, it's not necessarily the actual the actual finding of defamation. It's the volume of costs that might be awarded that proves that has the chilling effect on the media company. Now, it's sort of important to say a lot of what's happened, and we heard this repeatedly in evidence that we got, is that the Northern Ireland defamation law has promoted lots and lots of settlement, not just settlements out of court, but settlement long before a writ is ever issued. Now, some might say, indeed, Mr Tweed, who's been mentioned already, Paul Tweed, a very eminent and successful and, yes, authoritative libel lawyer, might say that that's a perfectly proper way for these things to proceed. And in some instances, that may well be the case. And I don't think we would want to see a situation in which every engagement between a libel lawyer and a potential plaintiff in the media company proceeded to trial. But the evidence to me is fairly clear that it's at the minute far too balanced on the side of litigants who want to, as it were, sell quickly and perhaps even directly or indirectly have a chilling effect on the behaviour of a particular journalist or a particular publisher going forward. And we did hear that very clearly from at least one journalist in our evidence, and I've heard it, frankly, on numerous occasions from journalists in this region that happens, and often it happens at the behest, let's be blunt about it, of politicians in this place. And we heard very stark evidence about politicians from particular parties being very canny and very enthusiastic about using our defamation law to occasionally get some cash, but also occasionally to get an outcome they want in terms of the reporting on them. No, I haven't. Yes, how to go away?
Him being a politician like myself, that if someone printed something that was incorrect or lies, or a little lie, would you sit on your hands or would you be going to your solicitor?
If someone printed something that was a lie about me, yes, well, it would depend what the lie was. In certain circumstances, yes, I would go to my solicitor. Nothing I have said has suggested that I'm not saying we don't need a defamation law. By definition, we do. It's very important that legal recourse exists and that it's strong and clear. What I'm saying is that the clear evidence that we've got repeatedly through, and that I've taken from our consideration, is that at the minute it's skewed very often towards litigants in particular circumstances. Look, if I was defamed, I would be annoyed about it, but I'm not as I make this point multiple times in this chamber, I'm legislating for the whole of society, and part of the whole of society is a free press, and it is a defamation law regime that works sensibly. And by the way, if the outcome that he had talked about if the serious harm test and the provisions around jury trial for defamation had prompted the end of the world in terms of that, then I presume we would have seen it in England and Wales, but we haven't yet, I don't think. And it is a true point to make that the average person aren't huge users of defamation law. So this is about getting the defamation law right. But just to go back to clause 11 on jury trial, Dr. Scott was very clear that this was something that could shift the balance. And by the way, it's only if we think that judges aren't able to make careful decisions based on what we will hopefully set out in a new defamation law, but also case law. If we don't think judges are able to make those cases, then we're effectively rendering their judgment. We're saying that they can't make lots of other judgments, because there are lots of other areas of law in which judges are trusted to make subtle judgments on what's in statute and what's in case law. And by the way, this law would not preclude jury trial in any circumstances, but it would make it less automatic, which I think is sensible. I would also just say there were once or twice people did make the link between our history in this jurisdiction around not having jury-free trial for criminal purposes. Now, it's very important that there are very understandable and very substantial concerns around and sensitivities for very good reasons, because of the history of this place, around jury trial in relation to criminal proceedings. But it's also very important not to conflate these two. We're talking about civil proceedings here, and there are many areas in which it is routine for civil proceedings to happen without juries, and in fact this area of law is possibly slightly more exceptional in that jury trials are more routine. So from our perspective, this is a sensible measure, which is a sensible reform of the defamation law. It's not abolishing trial without jury, it's simply slightly raising the threshold for trial with jury in this particular area of civil law, which I think, based on the balance of evidence that we have received, is sensible. The other amendments from the bill sponsor are mostly technical. I've gone through most of them. The final one is around commencement, and I know he's had to do some work on that, and it seems sensible to us. So I've given our intentions there, Mr. Deputy Speaker. I very much hope this bill survives as intact, particularly with clauses 1 and 11, if possible today. But I will conclude my remarks at that. Thank you.
I call Andrew Muir.
Thank you, Mr. Deputy Speaker. I rise today to speak at the further consideration stage of this defamation bill as the finance spokesperson for the Alliance Party. I note that many of the amendments have been brought to this bill are largely technical, and to that end I will speak in relation to 3 of the clauses that are currently part of this bill. And the first clause I will speak in relation to is clause 1, which is in relation to serious harm. This bill is largely a copy of the Defamation Act of 2013, with some slight adjustments to reflect the fact that we are no longer a member of the European Union. Back when this bill was debated in the House of Commons, it was noted that the draft bill had originally sought the views of a test of substantial harm. However, after drawing on the views of both the Joint Committee on the draft bill and the balance of opinions received in the consultation on the bill, that bar was raised to serious harm, meaning that a statement must have caused or likely to cause serious harm to the reputation of the claimant. The serious harm requirement aims to discourage insubstantial claims from being made, whilst also ensuring that claimants can take effective action to protect their reputation when it has been seriously harmed. This clause does not seek to limit the amount of genuine defamation cases that are brought forward. It merely seeks to reform the law so that unfounded actions for defamation do not succeed. This clause is one of a range of aims to strengthen the environment in Northern Ireland for open and robust scientific debate and professional journalism. During committee sessions, of which the Alliance Party does not have a member on the committee, but we have been following this closely, the National Union of Journalists detailed how in Northern Ireland a number of very wealthy people have been able to bring defamation claims against people whose stories were not deemed to have caused serious harm. But these wealthy people knew that the Pacific journalist publishers could not afford to defend them. This chilling effect is widely known across Northern Ireland, and Clause 1 of this bill presents the opportunity to try to put an end to it. We owe it to our local news outlets and journalists with limited financial resource who are faced with daunting legal action by those who have the finance to access skillful lawyers. Other news outlets and journalists across the UK do not face this extent of coercion, as they benefit from these serious harm protections. The committee even heard evidence that suggested a satellite television broadcast was discouraged across the whole of the UK because of our current defamation laws in Northern Ireland. I am very conscious of developments within the Republic of Ireland and that they are in process of reviewing their defamation laws, and it has been recommended in Ireland that an anti-slap mechanism is put in place. The strategic lawsuit against public participation would tackle this issue of groundless and exaggerated lawsuits being filed by wealthy individuals against a weaker party in order to silence and intimidate with legal defence costs. It is vital that we take action now to tackle this problem in any way we can. An early decision by the courts in respect of the merits of a defamation action, as determined by Clause 1 of the bill, would limit both court time and costs, allowing for better access to courts for ordinary people who have limited means to seek protection or appropriate redress. As my colleague Mr O'Toole, who is no longer with us, said in the second stage of this bill, where is the evidence that this change in England and Wales has led to a huge increase in defamatory material going unchecked? This clause seeks to achieve a fairer balance between both parties in a defamation case and moves towards objective, fact-sensitive approach that will be firmed up through case law. Alliance will be supporting this clause today and voting to ensure that it remains part of the bill. In relation to Clause 5, which is operators of website. Clause 5 deals with operators of websites and creates a new defence for them where a defamation action has been brought against them. The term operators of websites has not been defined and also provides an exemption for operators of websites with regards to liability. This means that this specific defence can be used by social networks who host content alongside providing the platform that allows for mass publication. The exemption that is provided in the clause has been defined as being far beyond the defences under European Union e-commerce. Another concern that I have with this bill and this clause is that the possibility of a website operator being required to disclose the identity of a whistleblower when they are source of a post on the website. From watching back Finance Committee evidence sessions, it was clear that Department officials have serious reservations about this clause and the ramifications that it may have. Much of this discussion with regards to online safety is outside the scope of this bill, and also it does not fit within the Department of Finance's remit. The onus to create regulations for this framework sit within the Department of Finance. However, there is uncertainty regarding whether the Department has the finance or the resource to undertake this huge piece of work. Committee evidence also highlighted that England and Wales regulations on this issue have not been effective, and that some companies are not even adhering to them. The lack of clarity regarding website operators means that it is not only the big names of Facebook and Twitter, for example, that would be impacted by this clause. Local newspapers with online comment sections would also be subject to this legislation and could face huge costs with regards to the costs of moderation. Comments on newspapers and online platforms allow for discussion and debate, and with this also being a platform for free speech. We also understand the sincere intention behind this clause. I believe there are ramifications that could cause more problems than it could solve. It has been noted that there is a very real possibility of conflict between this clause and anticipated legislation in Westminster with regards to online safety. I am more than aware of the need for action in regards to online safety and to hold people to account with regards to statements that are posted online, particularly on social media. I do not, however, think this clause is the correct way to address this. This bill has allowed the issue of online safety, bullying, defamation and harassment to come to the forefront in our legislative process, and I welcome that. An online harms bill that can strike a better balance between the right to free speech and preventing vile attacks on others on social media platforms should be a priority for all legislators. Far too often, far too many people in this place know all too well the horrific experience of being attacked online with vile and hate-filled comments, posted often by strangers and anonymous trolls. Alliance believe that it is only right that a platform is provided for discourse. The considerations are made to how this cannot become a platform for fake news and abusive content. And whilst this bill is not the correct vehicle for doing so, organisations do need to step up their game in this regard. There is a real risk that this clause could have an unintended consequence of reducing the liability of social media operators even further than the urgent need for improved reform and legislation with regards to online safety and standards. To this end, the Alliance Party are minded to support the Committee's intention to oppose Clause 5, standing part of this bill. Lastly, in relation to Clause 11, trial without a jury. Clause 11 will remove libel and slander from the list of proceedings where the right to jury prevails. This does not remove the question of a jury trial entirely, as a court can order that a jury trial takes place, and it is also my understanding that a judge would retain discretion to order a jury trial if it is considered to be appropriate. In 2014, the Law Commission of Northern Ireland warned that the presumption of jury trials in defamation cases in Northern Ireland was exaggerating the costs of defamation cases in this jurisdiction, with this acting as a deterrent for both defendants and enticing them to settle outside of court instead. The Law Commission also noted that very few cases ever reach full trial, and that in recent years an increasing proportion of those are tried by the judge alone. In fact, from 2014 to 2020, there were 140 defamation claims in Northern Ireland. Only 17 of these claims resulted in a judgment. The 2016 Scott report detailed that because of the lack of change with regards to jury trials in defamation cases, the presumption of a jury trial continues to have a profound impact on the development of law here. Yes, no problem.
Is the member aware that under our present arrangements, either party can apply to the judge to have the trial by judge alone? That facility already exists. So whereas the presumption is that you will have a jury, either party can apply that it should in fact be judge alone.
I thank the member for his intervention, and I do welcome that, but this legislation is about improving this position in relation to jury trials for the reasons I am setting out here today. We know that the presumption of a jury trial in a defamation case raises both the cost and the complexity of cases. It also disproportionately discriminates against defendants. Dr Mark Hanna, a lecturer at Queen's University School of Law, who has undertaken research in relation to defamation law reform in Northern Ireland, gave written evidence to the Finance Committee and touched on this issue. He wrote, "One must recognise that these virtues of jury trials simply do not translate over to the complexities of defamation law. Even though provision is made for juries in defamation cases, they are rarely employed in the end, and yet their looming prospect causes defamation claims to settle early and allows the system to be gamed by plaintiffs to postpone any application of a threshold test. Open justice is, of course, extremely important to our society. In this instance, however, it must be recognised the virtues of jury trials do not translate to complex defamation cases." It is also noted that from committee evidence, lawyers that provided evidence remain fairly neutral on this clause and have not highlighted any major concerns. This clause brings Northern Ireland in line with the rest of the UK with regards to presumption of a jury trial in defamation cases. The Republic of Ireland's reform of defamation laws will see juries abolished for High Court cases also. So if this clause does not stand part of the bill, and this bill actually proceeds, which I hope it does, we will be the only place within these islands that have not updated this particular aspect of our legislation. In conclusion, Mr Deputy Speaker, Alliance will be supporting the technical amendments that are being tabled to this bill. We will be supporting clauses 1 and 11 standing part of the bill, and are reminded not to support clause 5 of the bill. This is another area where Northern Ireland is falling behind in relation to reform, and I welcome the bill sponsor bringing forward this private member's bill. It is important that we act now to ensure freedom of speech and bring to an end far-fetched and amplified defamation claims. Thank you.
I call Jim Allister.
Thank you, Mr Deputy Speaker. The last words of Mr Muir, and indeed the exhortations of Mr O'Toole in support of freedom of speech, I trust when we come to the next debate, those matters will also be forefront to their mind, and that they won't be voting to suppress freedom of expression. But on this bill, Mr. Deputy Speaker. I want to focus on Clause 1, because Clause 1 is the nub of the issue here. For decades, our defamation law, which is a very important protection for all citizens, be they from whatever level within society. For generations, our law has been based on the very simple but effective premise that if something is written or said about you which causes damage to your reputation in the eyes of your peers, then you have been defamed. And if you've been defamed, you're entitled to recompense. And the recompense is in direct proportion to the quantum of the defaming. In other words, if the harm done is small, the damages will be small. If the harm done is great, the damages will be great. What this bill seeks to do, by importing into Clause 1 a fresh threshold, it takes away the present situation and substitutes the fact that the plaintiff, the person who says they've been defamed, has to do more than show they have been merely defamed in the sense of harm caused to their reputation. They have to show that serious harm has been caused through their reputation. Now, I should remember the onus to do that is on the citizen, the plaintiff. But what that means in practice is that Clause 1 gives an amnesty for non-serious harm. So if you sell a small lie rather than a big lie, that's okay. You get away with it. That is the real offence, to me, of Clause 1, that this House is being invited to legislate to the effect that you can tell lies, falsehoods about other people, and provided it doesn't cross the threshold of serious harm, then that's okay. Yes?
I thank the member for giving way, and wouldn't you agree with me that even more concerning is the fact that this is applying to the social media age that we live in today, whereby many people, particularly can take target via online to target people and defame them in a way in which, if this bill and this particular clause was to be changed in the manner in which he suggests, would mean, therefore, that these defamation and indeed damaging character assassinations would go simply unchallenged.
The member's right. I've heard talk in this debate, we need to get the balance right. Sorry, Deputy Speaker, there's no balance in favour of lies. None whatsoever. And Clause 1 seeks to introduce an amnesty for saying things about people which are false, which defame them, but does not sufficiently defame them. That is unconscionable, I suggest to this House. If something only causes minor damage, and some libels and slanders only do cause minor damage, then that is reflected in the quantum of the damages. That's the way it should be. And that's why in the committee we discussed the fact that a small case can, with very little expense, be properly taken and disposed of in the county court, where the jurisdiction is presently far too low. You can't bring a case worth more than £3,000 on defamation in the county court. It should probably be 10 times that. But if it were, then the costs which are paraded in respect of defamation cases, that point would be dealt with, because all those cases would be at a level of manageable costs for most people, because it would be scale costs, as they are in the county court. But the fundamental here, and the basic question for this House is, are we in this House going to endorse the principle that it's all right to reduce someone's reputation by the lies you tell about them, provided you don't go too far? That's the fundamental question. And that is a question that I cannot sustain a positive answer to, and therefore I must and will oppose Clause 1. And really, without Clause 1, this bill isn't of great weight. It modernises in its terminology the current defences of justification and fair comment in clauses 2 and 3, which is fair enough, and it deals with some other matters. But the real burden of this bill turns upon Clause 1. And for the reasons I've given, Mr. Deputy Speaker, I think that Clause 1 should be rejected.
I now call the Minister of Finance, Conor Murphy.
I have previously expressed my preference for a bespoke piece of legislation on defamation rather than simply replicating the law of England and Wales from 2013. The Irish Government has just published a review of defamation, and I have asked my department to examine that report, as well as the experience in England and elsewhere, so that we can bring forward a modern piece of legislation in the next mandate. That said, we have a bill for consideration in front of us, and there are aspects of it of which I have no difficulty with. The statutory codification of the defences, for example, is a measured and appropriate step in the development of our law. But turning to the specifics of the bill, Clause 1 seeks to introduce a serious harm test, and this clause has provoked much debate, including this morning. My concern is that people who don't have a public profile would find it more difficult to prove serious harm. Therefore, this clause would make it more difficult for ordinary people to protect their reputation. The concern is clearly shared by the committee, having discussed the defamation bill over many weeks and having heard evidence from a range of witnesses, including lawyers, academics, media representatives and officials from my department. The committee's decision is that the clause should not stand part of the bill. Two arguments have been made in support of this clause. One is that it will remove what has been called the chilling effect, and we've heard of that this morning as well, of our current defamation law. The chilling effect occurs when a news story, for example, is withheld because the author, publisher or editor is threatened with legal action. But no journalist should be afraid to print a story if it's true, and we have a defence in our law for that already, and it is given certainty and clarification in this bill. Furthermore, there is no evidence that it is more of a problem in this jurisdiction than it is in England and Wales, where the serious harm test has been in place since 2013. The second argument is that if we don't bring our defamation law into line with England and Wales, we will see a rise in libel tourism. It's claimed that people will come here to take advantage of our supposedly more lax defamation law. But if that was the case, we would have seen a rise in libel actions here after England and Wales changed their law in 2013, and we have not seen that. I therefore have reservations about Clause 1, and I agree with the committee that it should not stand part of the bill. I am content to support the amendment to Clause 3 and the clause as amended. The amendment tabled by Mike Nesbitt, the bill's sponsor, flows from a recommendation from Professor Andrew Scott in his 2016 report on defamation law reform in this jurisdiction. Professor Scott thought that the original wording from the Defamation Act 2013 was too limiting. It allowed a defendant to rely on a fact published before the allegedly defamatory statement, but not at the same time. The committee concluded that this amendment should stand part of the bill, and I agree. I now turn to Clause 5 of the bill. One of the reasons why I favour this bespoke bill, and not simply a replication of the 2013 Act, is because of the advances in social media since then. Addressing the challenges for defamation law in a world where social media is thriving is perhaps the most pressing challenge when it comes to defamation law. I note the decision of the committee with regard to this clause, which is that it should not stand part of the bill. I note that 6 members voted in favour of this position, with only 1 against and 2 abstentions. This is a conclusion based on many weeks of review, during which evidence was heard from a range of witnesses, including lawyers, academics, media representatives and officials from my department. I agree with the Committee's decision and note in particular the Committee's opinion that this clause may have the unintended consequence of further reducing the liability of social media operators. I welcome the fact that the bill sponsors also decided to oppose this clause. This is an area where I think we need to take time to reflect on how best it is to proceed and develop a bespoke solution appropriate to modern circumstances. Clause 11 of the bill ends the presumption in favour of trial by jury. In practice, it means the de facto abolition of trial by jury in defamation cases. That has been its effect in England and Wales, where there has not been a single defamation case that involved a jury trial since the advent of the 2013 Act. In this bill, akin to the position that England and Wales found itself in, the removal of the presumption of the relevant part of the Judicature Act has the effect that the Section 62(4) of that Act then applies, and that provision means that a jury in a defamation case can only take place in very restricted circumstances, mainly where the court is of the opinion that there has been an allegation of actual fraud or actual undue influence. It appears that the "for some other reason" aspect of that provision has not been utilised, and the net effect seems to be that the proposed clause will effectively end jury trials for defamation cases. I note some of the arguments presented to the committee that the prospect of a jury trial creates a degree of uncertainty around the outcome of a defamation case. Members of the media argued that a jury trial can mean lengthy and costly legal process. Juries can make high awards to claimants and awards that are sometimes seen as disproportionate, although the current law permits an avenue for such awards to be considered in appeal. Others point to the fact that Professor Scott noted in his report, in which he suggested that dispensing with the jury in defamation cases might make for a shorter process with a greater scope for an early resolution. At the same time, he noted the historical importance of the jury in our local context and that a jury decision might have more legitimacy than one taken by a judge alone. The defamation subgroup, which was part of the review of civil justice, did not want to see the jury trial abolished. It was in fact unanimous on that point. It commented that the juries were well placed to determine what a particular statement meant in the local context and whether it might be considered defamatory in that context. Therefore, Las Concorda, to accept this clause is to accept the end of jury trials in defamation cases. That may mean that in the future there is an earlier resolution in defamation cases, but perhaps at the risk of a loss of legitimacy. Judges discharge a very important and valuable role in our justice system, but is a judge always best placed to determine meaning in certain defamation cases? The subcommittee considering the issue in 2017 for the Civil Justice Review seemed to argue against the idea of removing juries in defamation cases. I note that the review in the South recommends similar changes, but I expect this recommendation to be challenged. As Finance Minister, I am in agreement with the committee and believe that this clause should not stand part of the bill. Before my concluding remarks, I want to comment on two other amendments tabled by the bill sponsor, Mr Nesbitt. Amendment 7 introduces a new clause in the bill, one that will require my department to review and report on the law in this area over the coming 2 years. It is good practice to review legislation, and I agree in principle with this new clause. It will provide an opportunity to take account of new thinking on online defamation in particular. My department will continue its work with the time to properly examine the recent developments, including the review south of the border. Amendment 15 seeks to change when the provisions of this bill come into effect, and part of that will depend on whether we agree to keep Clause 5 in place, but notwithstanding that, the desires for the bill to come into force around the time of royal assent. And while I am content to see provisions come into effect without undue delay, there are others within the justice system who will have an interest when this new law comes into force. The Department of Justice and the Court Service will be interested if jury trials are no longer required. This will need to be taken into account in their plans. My own view is that a commencement when all things are ready is preferable, but I will not take issue with the amendment that is tabled today. Last Concordia, I have no particular comments to make on most of the other amendments tabled by the bill sponsor. My officials met him recently and ironed out some of the technical issues with the bill and provided assistance along with the bill office on those. I am keen to ensure the bill is legally coherent, even where we clearly differ on policy, and my officials will continue that process once consideration stage is over and we have a clear picture of the shape and nature of the bill. In conclusion, I'll ask Concordia, there are aspects of this bill which I can support, others that unfortunately I cannot. My department will use the review period to consider this bill, whatever shape it ends up, along with other developments related to this area, and I hope that the end product will be beneficial for those who seek to protect their reputation, as well as considering those who wish to articulate their freedom of expression. There may be some more work to be undertaken before we reach that particular destination.
I now call the sponsor of the bill, Mike Nesbitt.
Deputy Speaker, thank you very much indeed. I should probably begin with a declaration as a Deputy Chair of the All-Party Group on Press Freedom and Media Sustainability. Probably doesn't need said, but I declare that for a large part of my adult life I earned a living as a journalist, working for many of the print and broadcast media outlets who operate in this jurisdiction. That might explain my interest in the laws of defamation, but it does not explain my motivation. As Mr McHugh put it, I am interested in making sure we have the best possible balance between what are often the competing rights of freedom of expression and the right to protect one's reputation. Deputy Speaker, I will heed the Speaker's written advice recently not to waste the time of this Assembly rehearsing points, positions and arguments that have already been made and rest in the official record of this House. So, having started this process 8.5 years ago, I find myself about to be much more brief in my comments than I anticipated all that time ago. To address a point that some members have made that perhaps this is being rushed, I just want to emphasise I started my consultation 101 months ago in September of 2013. I remember putting in everybody's pigeonhole the consultation document and the offer of a briefing. And more recently, as I revived this bill after the 3-year hiatus, I offered to meet any member, any party, any grouping who wanted to meet me to have a briefing about the bill. And only one party took up that invitation. So perhaps there have been missed opportunities on both sides. And in terms of the lack of cooperation between myself and the Department, I believe that is down to a misunderstanding. The first time the Department wrote to me, they talked about getting together to have a discussion. What they didn't do was finish the letter with, if you're interested, please contact X on Y phone number or Z email. So I was waiting for contact from the Department. But we cleared that up, and the second time we agreed to meet, we did meet, and I think it was a very useful meeting. And I thank the departmental officials and the Office of Legislative Counsel and the Bills Office for their assistance with that. And on the question of thanks, can I thank every member who has contributed to this debate. I want to thank the committee, both the members and the staff, for the considerable attention they gave to the bill at committee stage. I need to thank the Speaker's Office for ensuring the bill was competent, and also the Secretary of State for allowing me to legislate in an area which is reserved, namely telecommunications. I thank the Bills Office, the Office of Legislative Counsel, departmental officials. There are external helpers who I will mention at a later date, but I also want to thank the Minister, not just for coming here on a Wednesday morning when I'm sure he has many other duties to perform, but also because I know that his department's very strong first preference was that there should have been no legislative movement on this area during this mandate. So I think it's important to explain why I went ahead. And there are two main reasons. The first is that I don't think there is ever a perfect time to legislate on defamation. It's a moving feast. And I would quote the example of the fact that the Government of Ireland is now being asked to review their laws of defamation. Scotland very recently brought in a Defamation and Malicious Publications Act. So we're constantly updating in jurisdictions around us. The second is, will there be an Assembly and Executive functioning in a manner post the 5th of May that would allow us to bring forward legislation in this area? I hope there is, but there's clearly a question mark against that, and I think that's important, why we continue to have the Department review what is happening both here and in other relevant jurisdictions. As members have pointed out, my original intent was to simply replicate the 2013 Defamation Act in England and Wales, and I accept that's not going to happen. But I also want to point out that Dr. Scott, now Professor Scott, the man who the Department of Finance commissioned to conduct the in-depth consultation and to produce the report, has said that replicating the Act actually has some serious advantages. At paragraph 18 of the written evidence which he gave to the committee on the 29th of October, he said consistency with English law is now arguably a more pressing issue than it was when he reported in 2016. He said it would become increasingly inappropriate for Northern Ireland judges to rely on English law as a guide to the operation of the common law defences retained in this jurisdiction, and I think we can address that by some of the clauses that I have put in to this bill. So let me turn to serious harm, which so many members have difficulty with. I understand the committee did not support Clause 1. I understand members don't support it, and I understand the Minister doesn't support it. Dr. Scott made clear in that written evidence at paragraph 17 that the outcome in England and Wales is not what was expected, that in fact some judges in England and Wales are reverting to the old test, the one that we have, which frankly is, does the ordinary man and woman in the street think less of you when they are aware of the defamatory statement? It was also my intention, and it's clearly on the face of the bill, that you didn't simply have to prove serious harm had been done against you, but that it was likely to happen. But as I understand it, the case law in England and Wales suggests that actually you do have to prove serious harm has actually occurred. Mr. McHugh said it was effectively a licence to print lies, a sentiment repeated by and large by Mr. Allister. I disagree. I was a journalist for many years. I never deliberately printed a lie, big or small. I did sometimes print or speak factually inaccurate comments. I made errors, some small, some large. And if I may, I will take exception to Mr. Allister, who implied that anybody seeking to take a defamation case was seeking recompense, seeking money. Not necessarily, Mr. Allister. Some people want, I will go away in a second, some people want redress. Some people simply want an apology. Want, for example, me as the journalist to say, I'm sorry, I got that wrong. I really regret that. But in his comments, Mr. Allister made clear, everybody, well, that was his implication, everybody wants money by way of redress.
Recompense can embrace money, of course. It can embrace apology and withdrawal. But under the Members' Bill, unless you get to the threshold of serious harm, you get no apology, you get no redress. So you get away scot-free with telling the lie if it doesn't cause serious harm.
Thank the member for his intervention, but he didn't make that point when he was making his comments earlier on. It was all about the money. And I'll come to the county court, if I may, in a second. I'm not going to die in a ditch over serious harm. I understand that the clause is gone, but I would like to make a couple of further comments, Deputy Speaker. The committee are very keen that I look at pre-action protocols and the potential benefits of alternative dispute resolutions. And at one point I did have an amendment to that effect, which would have allowed a judge to order plaintiffs and defendants to engage in ADRs before the commencement of a trial. Well, with thanks to the Minister for Justice, she wrote to me on the 16th of February on this issue to point out that Lady Chief Justice Keegan's office is currently undertaking a targeted consultation on a draft pre-action protocol for defamation, media and communication claims, and that may apply to defamation claims listed in the High Court. And the aims are to promote early settlements without the need for proceedings, to avoid unnecessary expense and to control costs of resolving disputes. So it was on that basis I did not bring forward that amendment. And to go out of sequence and to cover another issue raised by the Justice Minister, it's the one Mr Allister referred to with regard to civil actions in the county courts. Mr Allister's argument, I believe, is that it is a deterrent for a potential plaintiff to go to a county court if their redress is basically built around their desire for financial recompense, because the upper limit in the county court is currently £3,000, and Mr Allister talked of maybe raising it as high as £30,000. Now, I did have an amendment which would have put a duty on the Department of Justice to consult and bring forward proposals in this area. The Minister has said that work is already ongoing by her officials to increase the general civil jurisdiction of the County Court, and that would include financial limits in defamation cases. She does go on to say, I have not come to a definitive view in that area, but she does make the point that it would be duplication on my part to have put the amendment in the bill, and so that's why it did not come forward today. Mr Speaker, clauses 2, 3 and 4 has already been debated. Basically tie, decodify, transfer common law into statute. I don't think anybody has a particular difficulty with that. The Deputy Chair of the committee advised the House that in terms of my amendment to clause 3, that I dropped the second half, which was a defence for any fact the defendant reasonably believed to be true at the time the statement was published. The reason I dropped that was after consultation with departmental officials and the Office of Legislative Counsel, because they believed it did not achieve what I was setting out to achieve. So on their advice, that part of the amendment has not come forward. Clause 5 is the one where the Secretary of State gave me consent to legislate in a reserved matter, that of telecommunications. I have to accept that I have not succeeded in making my argument. And I did say at second stage that I wouldn't die in the ditch. I had no red lines. I was open to persuasion on every clause of this bill, and I have listened to the committee. And I have listened to members in the House today. I don't necessarily agree, but I accept I haven't made my case, and so I will vote with the committee against this clause. But I would like to say something else, Deputy Speaker. 2 members of this House during this mandate were defamed on social media, both females, by the way, and that is an issue. Gender is an issue in this whole piece. One was clearly able to identify the author who posted the defamatory remarks on social media, and quite rightly went to the High Court, and quite rightly was successful in suing for defamation and receiving compensation. The other has no idea who posted quite outrageous and frankly sickening comments about her and her husband and her family, because she can't identify the person who posted. And that's what I was trying to achieve in clause 5. What I was saying was, if you see a post and you can't identify the author, you go to the operator of the website and you say, identify that person. And by identify, I mean identify in a way that I can get them into the High Court and sue them. And if you don't, because you don't want to or you can't, then I'm coming after you, the operator of the website. And I want to give you another example, Deputy Speaker, because a couple of weeks ago I posted a tweet about some victims. And one of the respondents, who I will not name because I'm not going to give them the oxygen of publicity, maybe a man because their photograph is of a man. But this is the response I got from this individual. A quote-unquote victim's advocate of the specific named individual, gun runner school, comparing me to a loyalist gun runner, and then going on to say of me, no Fenians need apply for empathy or support. I would suggest to the House that's defamatory. And just out of interest, I sent it to a media lawyer. My client confidentiality restricts me from telling you who it was. But you may wonder if the individual media lawyer has already been named in this debate. The key point of his written response was this: if you can identify him, it may be worth considering. If you can identify him. And yet Mr McHugh quoted Paul Tweed as saying that Clause 5 was totally unworkable. The intent was to identify the person responsible for the tweet. And my lawyer said if you can identify him, it may be worth considering. However, I accept that basically it's gone, and I also accept Mr Muir's comments that online safety is a much broader thing than online defamation. And it is very complex. And I think the bottom line here is that we legislate, we don't enforce, and the problem is more on the enforcement side than the legislative side of the House. So I leave it there, Deputy Speaker, on Clause 5. I'll join the committee and the House in voting against the clause. Clause 6 is on peer reviews. Clause 7, technical changes to reporting. Clause 8 tidies up the law regarding repetition of a defamatory statement. I understand that there are those members in the House who do not accept. Clause 9 deals with libel tourism, and the amendment just tidies up an error which left us within the European Union, which clearly is not the case. I accept that there is currently no...
Just your comment again on Mr Tweed, but would you accept too that I had actually commented on the fact that where many of the people who utilised, say, the uses of the internet and the likes of it, or social media, that because they were unknown, that was what actually made it unworkable. And if anything, Mr Tweed's advice to you, does that not but confirm exactly what I was saying, that because many of them are unknown, it is unworkable?
I thank the member for his intervention, but I don't accept his premise. The fact that the person is unknown is the issue. What I'm saying is, we are not the courts, we don't enforce the law, but we make the law. And what I was proposing was that we made a new law that made it basically a criminal offence for the operator of the website not to identify the individual, that we put a legal onus on them to say, if you receive a complaint, say from me about the tweet I've just mentioned, then you must identify that individual to me so that I can brief my lawyer and we can proceed with defamation in the High Court. And if you don't, for whatever reason, then I'll come after you, be you tweet, Facebook, whatever. But the difficulty is, I would say, the legal enforcement And that's not us. We legislate, we do not enforce. To return to libel tourism, I accept absolutely that there is no evidence that libel tourism has or is occurring in Northern Ireland. But I want to just plant the thought that if we don't go with Clause 11 on jury trials, and we become potentially the only jurisdiction on the two islands who retain the presumption to jury trials, that might make a difference in terms of libel tourism. I note those who are opposed to Clause 10 on the definition of author, editor and publisher. What I would say to you is this is intended to offer protection to those who would be involved in the dissemination of information who do not meet those definitions. So let me take you, for example, to a publishing house, a printers. Sorry, not a publishing house, a printers. So let me say I run a printing firm, and I'm struggling. Print newspapers are struggling because of the internet. People read more books online and on Kindles and other machines than buying hard copies out of shops. So let's say I am a printer, so I'm really struggling to get business in. Do people come and say, please print my publication? And somebody comes to me from a university and says, I'm a scientist and here's a 1,000-page book. Would you please print it? Do I have to go out and get a scientific expert to read every word of those 1,000 pages so that he says, on page 732, paragraph 5, there is something that is potentially defamatory? What is the additional cost of that to that printing house? That's all I'm saying in Clause 10. The people who would be deliberately disseminating the defamatory statement would either be an author, an editor, or a publisher.
The member agree with me just on the flip side of that argument. If someone posted someone about anybody in this House on Facebook, for example, and someone reshared that, would Clause 10 let them off the hook?
They would be a publisher, would they not? They will have chosen to reprint, to republish the defamatory comment, would be my interpretation of Clause 10.
Is there any read across from that answer to Clause 8, the single publication rule?
There is potentially, if you run out of the 1-year time limit, Mr. Alistair. Yes, there is. I'd now like to move to the last kind of substantial comment that I have to make, Deputy Speaker. It's Clause 11. Jury trials in civil law are rare, as I understand it. They certainly are not available in England, Scotland and Wales, and there's every possibility they will soon not be available in the jurisdiction of the Government of Ireland if Minister Helen McAtee's recommendations are accepted. Here I want to return once again to the evidence of Professor Scott, and again I remind members that he was commissioned by the Department of Finance back in the day to look after the consultation and write the report. And in his evidence of the 29th of October in writing to the committee, the first thing he tackled was the move to judge-only trials, and his headline was highly beneficial consequences. And what he said was it allowed questions of fact to be considered at a preliminary stage. Preliminary hearings now habitually address the determination of meaning and the matter of whether an impugned statement should be understood as fact or opinion. The current law in Northern Ireland sees the determination of these matters left inefficiently to the end point of litigation. This increases costs and expands the opportunity from game playing by relatively powerful litigants. So, just to be clear, if one of us goes to the High Court with a claim for defamation, because there is a jury, the judge will only decide whether the statement is capable of being interpreted as defamatory. So if it is perverse, for example, he can throw it out or she can throw it out. But if it's capable of being interpreted as defamatory, the trial goes ahead and the jury decides. And I'm sure we have all said things, possibly even in this House, and felt we've known exactly what we meant, only to discover that somebody else has a different interpretation. So this is key to the whole issue of defamation. You have to have, at the end, a single meaning. And currently it's the jury, at the end of the trial, who say, well, those words mean X, not Y. So the plaintiff's right or the defendant's right. So what Professor Scott is saying is that if you go for a judge-only trial, the evidence is that right up front, the judge, because he's not giving the jury its place, because he or she is not having to give the jury their place, can simply say right up front, I think those words mean X, and therefore it's defamatory, or it's not defamatory. And it seems to me that is a much more efficient way of dispatching a defamatory action, particularly if we're thinking about new pre-trial protocols and alternative dispute resolutions. And before I give way to Mr. Allister, let me just finish by the conclusion of Professor Scott. The importance of this change, the move to judge-only trials, cannot be overstated. It was perhaps underappreciated and hence understated in the 2016 report.
If defamation is whether or not someone's reputation has been lowered in the eyes of the public or their peers, is there not a natural correlation then in letting the public, as represented in the jury, decide what the alleged libel actually means? Is that not the correct correlation there?
Well, as the member is aware, because the point has been made in the debate, very, very few defamation trials go to jury trial at the moment. Mr. Allister himself has made the point that plaintiff and defendant can both say, I would rather have this trial conducted by a judge only. What I'm saying is, I think this is a much cleaner, efficient and potentially cost-effective way of dealing with the issues. It seems to me almost perverse to say we won't decide on the meaning of the words until the end of the trial. Let's get it done up front and let us move on. Deputy Speaker, I will not delay the House much more than another minute. I think a lot of the rest of the clauses are basically technical, but I do have an Amendment 7, which places a new duty on the Department of Finance to keep under review all relevant developments and report to the Assembly within 2 years of royal assent. I think that's sensible, acknowledging the ever-changing nature of the defamation environment. I think it's sensible given the potential for what might or might not happen after the 5th of May. I have changed the time limits, as the Deputy Chair pointed out. That was done in negotiation in terms of the commencement. The Deputy Chair has pointed out I've changed the time limits for that in Amendment 15. These were negotiated recently with departmental officials, and I think while the timescales are not without their challenge, I believe that they're realistic and that there was no particular objection from departmental officials to Amendment 15. So, Mr. Speaker, I shall leave it at that, and once again just thank all the members and the Minister for their attention.
I now call the Deputy Chairperson of the Committee for Finance, Keith Buchanan, to wind.
Deputy Speaker, I'd like to thank all the contributors to the debate today in respect to defamation. I'm not going to go through each contribution. You'll be glad to hear, because to be fair to the bill sponsor, he's covered that. There's no point in me going over old ground. I'd also like to thank the sponsor and the Minister for the oral and written briefing information which was read at the committee. Regardless of the outcome today, I think that it is always to a member's credit when a private member's bill is brought to the Assembly. It is a lengthy and demanding process and can prove to be quite testing for the member involved. The issues in the bill were important and are important, and include free speech, a free press, excessive social media commentary, the protection of reputation. Thus, it is hardly surprising that some of our exchanges today are somewhat differing in views, which is obviously the reason we're here. Notwithstanding this, I think this debate has been useful and illuminating and will help to inform the Assembly as we come to consider the amendments on the Marshall List. Thank you very much, Mr. Deputy Speaker.
Before I put the question, members, I would remind you that we have debated the opposition to Clause 1 stand part tabled by the Chairperson of the Committee for Finance. But the question will be put in the positive as usual. So the question is that Clause 1 stand part of the bill. All those in favour say aye. Contrary, no. All those in favour say aye. Contrary, no. I think the noes have it. I think the noes have it. The noes have it. The noes have it. Amendment 1 has already been debated. I call Mike Nesbitt to move formally Amendment 1.
Moved.
Amendment proposed to Clause 2, page 1, line 19, leave out and insert words as printed on the Marshall List. The question is that Amendment 1 be made. All those in favour say aye. Those against, no. I think the ayes have it. The ayes have it. The ayes have it. The question is that Clause 2, as amended, stand part of the bill. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. Amendment 2 has already been debated, and I call Mike Nesbitt to move formally Amendment 2.
Moved.
Amendment proposed to Clause 3, page 2, line 12, insert words as printed in the Marshall List. The question is that Amendment 2 be made. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. Amendment 3 has already been debated, and I call Mike Nesbitt to move formally Amendment 3.
Moved, Deputy Speaker.
Amendment proposed to Clause 3, page 2, line 31, leave out and insert words as printed in the Marshall List. The question is that Amendment 3 be made. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. The question is that Clause 3, as amended, stand part of the bill. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. No amendments have been tabled to Clause 4. The question is that Clause 4 stand part of the bill. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. Amendment 4 has already been debated, and I call Mike Nesbitt to move formally Amendment 4.
Moved.
Amendment proposed to Clause 5, page 4, line 4, leave out words as printed in the Marshall List. The question is that Amendment 4 be made. All those in favour say aye. Contrary, no. All those in favour say aye. Contrary, no. I think the ayes have it. The ayes have it. The ayes have it. Before I put this next question, I remind members that we have debated the opposition to Clause 5 stand part tabled by the Chairperson of the Committee for Finance. But the question will be put in the positive as usual. So the question is that Clause 5, as amended, stand part of the bill. All those in favour say aye. Contrary, no. All those in favour say aye. Contrary, no. I think the noes have it. I think the noes have it. The noes have it. The noes have it. No amendments have been tabled to clauses 6 and 7. I propose, by leave of the Assembly, to group these clauses for the question on stand part. The question is that clauses 6 and 7 stand part of the bill. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. Amendment 5 has already been debated, and I call Mike Nesbitt to move formally Amendment 5.
Moved.
Amendment proposed to Clause 8, page 7, line 21, leave out and insert words as printed on the Marshall List. The question is that Amendment 5 be made. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. The question is that Clause 8, as amended, stand part of the bill. All those in favour say aye. Contrary, no. All those in favour say aye. Contrary, no. I am hearing ayes from many benches, but noes to my right from the DUP. I think The ayes have it. Clear the lobbies. The question will be put again in 3 minutes. Order, members. Would members resume their seats, please? Order. Again, I remind members that if they have proxy voting arrangements in place, they do not have to come into the chamber. The question is that Clause 8, as amended, stand part of the bill. All those in favour say aye. Aye. Contrary, no. No. Do we have tellers? You okay, Frank? Order members, the following tellers have been appointed. Tellers for the ayes, Andrew Muir and Mike Nesbitt. Tellers for the noes, Melissa McHugh and Keith Buchanan. Again, remind members to maintain social distancing, keep a 2-metre distance where possible, especially in the lobbies, and I remind you that you maintain this during the entire process. Clear the lobbies. The Assembly will divide. Ayes to my right, noes to my left. Secure the doors. Order member, would members resume their seat, please? And clerk, please read the result.
85 members voted. 31 members voted aye. 54 members voted no. The motion is negatived.
The motion is negative. The motion is negative. So that's Amendment 6. Amendment 6 has already been debated, and I call Mike Nesbitt to move formally Amendment 6.
Moved.
Member proposed to leave out insert words as printed on the marshal list. The question is that Amendment 6 be made. All those in favour say aye. Aye. Contrary, no. The ayes have it. The ayes have it. The question is that Clause 9 as amended stand part of the bill. All those in favour say aye. Aye. Contrary, no. The ayes have it. The ayes have it. No amendments have been tabled to Clause 10. The question is that Clause 10... Yeah. Just... Yeah. Just to clarify, the question is that Clause 9 as amended stand part of the bill. All those in favour say aye. Aye. Contrary, no. The ayes have it. The ayes have it. No amendments have been tabled to Clause 10. The question is that Clause 10 stand part of the bill. All those in favour say aye. Aye. Contrary, no. All those in favour say aye. Contrary, no. I've been advised by party whips that in accordance with Standing Orders 113(5)(b) that there is agreement that we can dispense with the 3 minutes and move straight towards the division. So I now call for tellers. Do we have tellers? Order members, the following tellers have been appointed tellers for the ayes: Mike Nesbitt and Claire Sugden. Tellers for the noes: Philip McGuigan and Keith Buchanan. Again, remind everyone to maintain social distancing as they take part in the voting arrangements. Clear the lobbies. The Assembly will divide. Ayes to my right, noes to my left. Secure the doors. Order members. Clerk, please read the result.
85 members voted. 31 members voted aye. 54 members voted no. The motion is negatived.
The motion is negatived. The motion is negatived. So that's clause 11 then. Before I put the next question, to remind members that we have debated the opposition to clause 11 stand part tabled by the chairperson of the Committee of Finance, but the question will be put in the positive as usual. The question is that clause 11 stand part of the bill. All those in favour say aye. Aye. Contrary, no. All those in favour say aye. Contrary, no. Do we have tellers? As per 113.5b, there's been agreement that we can dispense with the normal 3 minutes wait, and we will go straight to tellers. Do we have tellers? Order members, the following tellers have been appointed. Tellers for the ayes, Mike Nesbitt and Claire Sugden. Tellers for the noes, Gemma Dolan and Jim Allister. Again, remind members to maintain social distancing during the voting, especially in the chamber, the rotunda and the lobbies. Clear the lobbies. The Assembly will divide. Ayes to my right, noes to my left. Secure the doors. Order, members. Would members resume their seat? Clerk, please read the result.
58 members voted, 31 members voted aye, 27 members voted no. The motion is carried.
The motion is carried. The motion is carried. Unfasten the doors. No amendments have been tabled to clauses 12 to 14. I propose by leave of the Assembly to group these clauses for the question on stand part. The question is that clauses 12 to 14 stand part of the bill. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. Amendment 7 has already been debated, and I call Mike Nesbitt to move formally Amendment 7.
Moved.
Amendment proposed that after clause 14, insert new clause, review of defamation law. The question is that Amendment 7 be made and the new clause added to the bill. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. Amendment 8 has already been debated, and I call Mike Nesbitt to move formally Amendment 8.
Moved.
Amendment proposed to clause 15, page 9, line 22, insert words as printed on the marshalled list. The question is that Amendment 8 be made. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. Amendment 9 has already been debated, and I call Mike Nesbitt to move formally Amendment 9.
Moved.
Amendment proposed to clause 15, page 9, line 24, insert words as printed on the marshalled list. The question is that Amendment 9 be made. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. The question is that clause 15 as amended stand part of the bill. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. Amendment 10 has already been debated. I call Mike Nesbitt to move formally Amendment 10.
Moved.
Amendment proposed to clause 16, page 9, line 31, leave out and insert words as printed on the marshalled list. The question is that Amendment 10 be made. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. Amendment 11 has already been debated. I call Mike Nesbitt to move formally Amendment 11.
Moved.
Amendment proposed to clause 16, page 9, line 34, leave out and insert words as printed on the marshalled list. The question is that Amendment 11 be made. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. The question is that clause 16 as amended stand part of the bill. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. Amendment 12 has already been debated. I call Mike Nesbitt to move formally Amendment 12.
Moved.
Amendment proposed to clause 17, page 10, line 9, leave out and insert words as printed on the marshalled list. The question is Amendment 12 be made. All those in favour say aye.
Aye.
Contrary, no. The ayes have it. The ayes have it. Amendment 13 has already been debated. I call Mike Nesbitt to move formally Amendment 13.
Moved.
Amendment proposed to clause 17, page 10, line 13, leave out and insert words as printed on the marshalled list. The question is that Amendment 13 be made. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. Amendment 14 has already been debated. I call Mike Nesbitt to move formally Amendment 14.
Moved.
Amendment proposed to clause 17, page 10, line 16, leave out words as printed on the marshalled list. The question is that Amendment 14 be made. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. The question is that clause 17 as amended stand part of the bill. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. Amendment 15 has already been debated. I call Mike Nesbitt to move formally Amendment 15.
Moved, Deputy Speaker.
Amendment proposed to leave out and insert words as printed on the marshalled list. The question is that Amendment 15 be made. All those in favour say aye.
Aye.
Contrary, no. The ayes have it. The ayes have it. The question is that clause 8. Point of order, Mr. Oster.
Before we vote, could you clarify? Amendment 15 anticipates Section 5 still being part of the bill. Section 5 was voted down. So, in what shape then is clause 18? Is it is it going to include a commencement for a section which isn't in the bill?
Members take their ease for a few moments. Order, members. A point of order has been made by Mr. Allister. Having discussed the matter and thought about it, I am content that it is an order in that it can be remedied at the further consideration stage if there are any issues as such as been indicated. Moving on then, the question is that clause 18 as amended stand part of the bill. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. No amendments have been tabled to clause 19. The question is that clause 19 stand part of the bill. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. The question is that the long title be agreed. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. And that concludes the consideration stage of the Defamation Bill. The bill stands referred to the Speaker. Members, I propose by leave of the Assembly that we suspend the sitting for a lunch break until 2 p.m. The next item of business when we resume the sitting will be the consideration stage of the Abortion Services Safe Access Zone Bill. The sitting is by leave suspended.
Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary. Programme signed. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme signed. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound.
Members, we move now to consideration stage of the Abortion Services Safe Access Zones Bill. I call Ms Claire Bailey to formally move the bill.
Moved.
Thank you. Members will have a copy of the marshalled list of amendments detailing the order for consideration. The amendments have been grouped for debate in the provisional grouping of amendments selected list. There is a single group of 12 amendments, and opposition to clauses 1 to 13 and deals with protected premises, establishment of zones, offences, notices and definitions. Within the group, Amendment 2 is mutually exclusive with Amendment 1 and Amendment 9 is mutually exclusive with Amendment 7. I would remind members intending to speak that during the debate on single group of amendments, they should address all of the amendments on which they wish to comment. Once the debate is completed, any further amendments in the group will be moved formally as we go through the bill, and the question on each will be put without further debate. The questions on stand part will be taken at the appropriate points in the bill, and if that's clear, we will now proceed. We now come to the single group of amendments for debate. With Amendment 1, it will be convenient to debate Amendments 2 to 12 and opposition to clauses 1 to 13. Stand part. I call Mr Jim Allister to address his opposition to Clause 1 and other oppositions to clauses stand part, as well as the other amendments in the group.
Thank you, Mr Deputy Speaker. I have tabled opposition to every clause of this bill because this is a bill which I think carries and contains no merit. It is unnecessary when weighed against the current position of our law. It is a bill which is overwhelmingly vindictive in its approach, and it quite consciously and deliberately expunges and oppresses any legitimate protest whatsoever. It's ironic that there is no choice to protest permitted within this bill. It creates these censorship zones where even the attempt to influence is criminalised. And if I go to Clause 6, subsection 2, we see exactly how pervasive this bill is, because it makes it an offence in a zone with the intent or reckless to whether or not it has the effect of influencing a protected person, whether directly or indirectly. So the very issue of seeking to influence someone is now criminalised. And that influencing might be an entirely silent presence. It could be an entirely silent protest. It could be someone simply holding up the words of the 6th commandment, "Thou shalt not kill," in the context that that's what abortion is. So someone who chose not saying a word, not handing out anything, just standing quietly with those words would be criminalised by this legislation. That's how draconian and outrageous it is in its reach. And I do say to this House, though no doubt on past performance, my words will fall on deaf ears, but I do say to this House, stop and think what you're doing. You might be wholly persuaded of the merits and the desires of promoting abortion. That's not the issue. The issue here is, are you wholly persuaded that it is right in 2022 to create a criminal offence out of silent protest seeking to influence someone? Now, there's no point in glossing that over by saying, oh, but this is really to deal with harassment, which isn't even defined in the bill, or with abuse or violence, all of which are covered in the current law. No point in saying, oh, it's really to do with that. If it were really to do with that, then 6.2a would not be in the bill. But 6.2a makes it a criminal offence to seek to influence and creates these censorship zones at the behest of the operators. So I do say it is one of the most incredible things that any bill would so lose sight of fundamentals that it would put this draconian measure upon us. You know, freedom of expression, we were hearing about it in the debate before this, by some of the very people who I suspect will vote for this bill today, lauding freedom of expression. But freedom of expression provides equally for saying the unpalatable as it does for saying the palatable. There's no sifting in freedom of expression that you must only say that which is palatable. Freedom of expression also entails saying the unpalatable. But freedom of expression under Clause 6 in this bill is totally expunged. And therein is something that is quite unpalatable in itself. Even silent prayer is now a criminal offence. Someone could go to one of these facilities, stand within the zone, silently pray, indicating their position on these matters, and they could be capable of being criminalised. That's how dastardly the extent of this bill is. And of course, it doesn't exist anywhere else. The Home Office decided against it. Scotland decided against it within this United Kingdom. But here, we want to put it upon individuals and society in general. I said there's no definition of harassment. I made this point at the second stage. I thought the sponsor might at least have taken that under her notice, because harassment in law is already defined. It is defined as causing alarm, etc., which of course is also alarm or distress is the legal definition of harassment. But this bill, in its tautology, says causing harassment, alarm or distress. So what's the harassment here? It's obviously not alarm or distress. It's obviously not harassment as defined in the law. So one would have expected to see in this bill a definition of whatever harassment it is that this bill refers to. But that's maybe just a side issue. But where this bill gets really oversteps the mark is in its audacious move to create self-certification of zones, at least under the existing clauses. Under Clause 3, it was the Department, Clauses 3, 4 and 5. Following a request from the operator of the premises, the Department makes a determination that the premises will be treated as a protected premises. And it may only make that determination if it, the Department, is satisfied it's reasonable to do so. Along comes Amendments 3 and 4, and they remove. Amendment 3 removes that role for the Department and that obligation to ensure that it's reasonable to do so, and simply leaves a situation where a zone arises when it's self-certified by the operator. So they get to write their own laws, their own rules. They don't have to go through any filter of any department. All the department comes, its sole role is to hold a register of these places. But under Amendments 3 and 4, we have this absurd position whereby a zone is established on self-certification. That's the import of Amendment 4. If the operator of any protected premises is of the opinion that the public area mentioned in subsection 2b is not adequate to afford the safe access, etc., they can even extend it up to 150 metres. So they make it in the first, it's made in the first place, and then they can extend it on their own whim, self-certify it with no consent or needs for the department. And the only duty of the department is in 5A4, the department must include an entry relating to the premises in the list maintained under Section 8A. So it really is unbelievably audacious that this bill would bestow upon the operators the self-certification rights to create and to extend these zones within which to silently protest is a crime, within which to silently stand, as I've said, with a copy of the 6th commandment, thou shalt not kill, is a crime. Yes?
I'm not sure how many of the sessions you listened in on, but when we heard from the chief executives of the trusts, we heard about a woman who was coming to Northern Ireland to seek refuge here from Eritrea, and en route she was sexually assaulted. And when she arrived here to have her healthcare needs met, she was harassed at the entrance. And so, while I understand and I support the right to protest, I also think the needs of women in her particular circumstances and similar should have primacy in terms of their needs. Would you agree
The member
with that?
says she supports the right to protest, yet I guarantee today she will vote to expunge all right to protest. So there's not much point in her coming to this House and saying she supports the right to protest when she's going to vote to take out Clause 9.
People can protest, but outside the safe access zones. That is what I will be supporting today.
So you are going to create zones which are allowed to contain one world view, that of the pro-abortion view, and within that, even though it's a public place, it is outside the public right to express a view contrary to the pro-abortion view within that zone. That's how audacious this is. And if the member is saying that this is about harassment, then you don't need influence. You don't need to criminalise influence, because that is already covered in 6(2)(c). So, the point here is you have to look at a law. What is the breadth of it? And the breadth of this law is that it can criminalise mere silent protest if it is thought capable of influencing someone. I give an example in the second stage debate. Take the 14-year-old girl who gets pregnant. She's determined to have an abortion. Her mother doesn't wish her to. She wants her to deal with this in other ways. She tries to give motherly advice. The young girl says, "No, I'm going to do it." She heads down to the abortion clinic. The mother goes with her, pleading with her not to do it. Once the mother steps within this zone, she's the criminal, because she's trying to influence the minor not to proceed. She becomes the criminal. That's how absurd this is. Yes?
Thank you, Member. But if the member looks under clause 4b, accompanying person described in paragraph A at the invitation of that person will also be a protected person, therefore the mother that you're speaking of.
At the invitation of that person. If the child says, "I don't want you to come with me, I'm going to do this on my own, I'm getting an abortion, I don't care what you say," and the mother says, "I'm your mother, I love you, I care for you, I want to persuade you not to do this," once that mother steps over that line into this zone, that mother is a criminal, according to this law. And that is how absurd this legislation would be. We're going to criminalise mothers showing motherly concern for their daughters because they're not allowed within that zone to seek to influence the child. Now, really, is that what this House wants to do? That is beyond comprehension, I would suggest. Returning to this tyranny of self-certification, there's no oversight, there's no appeal, there's no proportionality. It's just on the whim of the operator. We want to extend it to 150 metres. That's all right then, you do it. No oversight, no asking the department, nothing whatsoever. And when you look at clause 8.2, it gives, as the bill presently stands, this is the notification of the zoning. Within 8 weeks of receiving this notification, the department must designate an area as a safe access zone. That's gone under these amendments. Amendment 8, all you do is you make the department the depository for a registry. They keep a register of where these profit-making organisations, some of them, self-certify and decree. The matter is beyond comprehension that any House would want to hand to profit-making organisations such as this that control over the public streets. Because that's what they're doing. This is public property. And they are going to self-certify who can and cannot go. And in taking out clause 8, of course, you take out the 8.3, the power to consult by the department. You take out the power in 8.4 to vary the determination. You take out the power in 8.5 to revoke. So all of that is to go under this. And then there's an amendment to take out clause 9. If there was any saving grace in this bill, it was the indication that in the exercise of its functions, the department must have regard to 3 things: safety and dignity of the protected person, the right to respect for private and family life in Article 8, the right to manifest religious belief, and the rights to freedom of assembly and expression set out in Articles 9, 10 and 11. What does the sponsor do? She comes along with an amendment to expunge clause 9. So the very essence of any regard to freedom of expression that was in the bill is now, by this sponsor, designed to be removed. So what you're left with is no-go zones for the department. These are zones of censorship, self-certified by the organisers, where it is a criminal offence to dare to breathe anything that might be interpreted as influence, and you just abandoned the zones to the control of the abortion clinics. That is what this legislation is now, through these amendments, coming to. So any semblance... Yes?
Thank you for letting me in. You keep using the word influence. Do you not think that by the time the woman or the girl has arrived for her healthcare services, that she will have already gone through an agonising process? So by this stage, she will have made up her mind. So I don't think it should be on anybody else to try and influence her at that point.
Well, the member might be so in favour of destruction of the unborn that she thinks that no one should have the right to try and influence someone not to destroy the unborn. But I disagree. It is one of the most fateful steps that any mother or anyone else can take to destroy the unborn. And surely we live in a society where legitimate influence should still be recognised and honoured, instead of expunged, as this bill, instead of criminalised, as this bill will do. So I really do say to the member that we are headed down a road which is quite shocking. And all of this with no regard to the existing law. Article 9 of the Public Order Act, Public Order of 1987 makes it an offence to use written material that is threatening, abusive or insulting. What's wrong with that? But patently it's not enough. Harassment is provided for in the Protection from Harassment Order 1997. You can even get a restraining order under that order. Disorderly behaviour is provided for in the 1987 order. Article 4 allows conditions in public assemblies. So if you have a situation where there's a routine of regular protests, they can be regulated by Article 4. But instead, along comes this bill and this sponsor to say, I want to even amend my bill to the point where anyone who steps foot within 150 metres of one of these abortion clinics will be criminalised if they dare to try and influence anyone. And some of these may well be in public bodies, public buildings that have other purposes. And the whole zone applies in respect of all of that building. You know, such unbelievable presumption on their part. The member referred to taking evidence. Yes, I had a look at the report. I was struck by how diffident the committee was in hearing anything but one side of the story. 6,459 submissions, written submissions, and only 13 of them supporting this bill. A slate of witnesses, but a refusal to hear from those opposed. This committee covered itself in, well, certainly didn't cover itself in glory in dealing with this matter. It covered itself in bias by virtue of the fact that the people it wouldn't hear from. And no doubt that same bias will be here today, refusing to hear. Yes?
It's just on that issue. I think it's important to note, in a defence to the committee, that the decision was taken that those people that were offering their view on abortion, not on the issue of access to the clinics, and that the decision was taken to listen to the people who had a view on that issue, because to have taken all of the issues in, we would have been reopening debates to which this particular legislation didn't cover, and that actually that's quite diligent and not biased, as you would put that through.
Was there not a group of laymen and ministers who asked to be heard and were politely, if it was politely, told to go away? We don't want to hear from you. Sure.
Those views were taken into account as part of the written submissions.
Yes. So you tell us written submission views were taken into account, and 6,459 were all against the bill, all but 13. And their views were taken into account, and here we are, still with the bill, with the chairman and others about to even make it worse by supporting these amendments. Who does the chairman think he's kidding when he says those views were taken into account? Over 6,000 objections to this bill. There's no evidence in this report that they were taken into account other than counted. They certainly didn't count when it came to the argument. And this was a committee which consciously and deliberately was deaf to views other than those which fitted the bill. And that is exactly how we got here. So it is a bill which is unworthy, in my respectful submission, of any support in this House. It drives a coach and horses through basic, elementary, lawful expectations as to freedom of expression. It outlaws that, and it elevates to a point that's unbelievable the rights of these abortion clinics to self-certify for themselves the zones, and removes the very department from any oversight of that. It is a quite appalling and unnecessary piece of legislation, because, as I've read to this House, there are multiple limbs of legislation which cover unruly, inappropriate behaviour outside in any public place, but not enough for this sponsor and this bill. They want exclusivity to only have their view capable of expression, and the right to even silent protest expunged. That is something I will not and cannot endorse, and therefore will oppose today.
Éireann Chaithilach and Coiste Sláinte, Colm Gildinu hon Cancha. I call the Chair of the Health Committee, Colm Gildinu.
Speaker, during the debate on this group of amendments, I will give a brief overview of the committee's scrutiny of this bill and will make some further comments on the committee's view on the bill sponsor's proposed amendments. The committee has not considered the amendments in the name of Mr Allister and Ms Bradshaw, and therefore there is no committee view on those amendments. So, the bill seeks to allow for the establishment of safe access zones outside premises which provide lawful abortions or related information, advice or counselling. The bill also creates offences which apply to safe access zones and allows the police to enforce these offences. The proposer of the bill, Ms Bailey, briefed the committee on the 7th of October 2021 on the principles of the bill. The bill passed second stage on 12th of October and was referred to the Committee for Health for scrutiny at committee stage. The committee issued a call for evidence, and there was a substantial response to the call for evidence, with the committee receiving a total of 6,459 written submissions. A total of 47 written submissions were received from organisations, with the rest coming from individuals. At its meeting on the 2nd of December 2021, committee members agreed to take oral evidence from a number of statutory organisations. Evidence sessions were held with the Department of Health, all 5 of the Health and Social Care Trusts, the PSNI and the Human Rights Commission. The committee also took evidence from the sponsor of the bill on 3 occasions. We received correspondence from Abolish Abortion on the 19th of January, asking the committee to reopen its evidence gathering to allow ministers and pastors to give evidence on the bill. The committee considered this request and outlined that there was a significant response to the bill from organisations, including responses from statutory bodies, staff representative bodies, professional bodies, pro-life organisations and pro-choice organisations. Members felt that the views of organisations and individuals were clear from their written submissions, and the members have used those written submissions to inform their views on the bill and therefore would not be reopening oral evidence sessions on the bill. The committee did receive a wide range of views, with the vast majority of individual responses not in favour of the bill. And I am certain that Mr Allister will understand that committees generally do not take evidence from individuals. It is also the case, and maybe Mr Allister could advise us, would he suggest we should have taken evidence from all 6,000 or just from the members whose view you support? So, I will.
We just finished debating the defamation bill. I sat on that committee. We heard from several individuals. So it's not alien. It's not alien to hear from individuals. But here you had 6,000 people expressing a view and you didn't want to hear from one of them.
Their view was clear and was presented to us, and I'm certain you're not suggesting we should have heard from them all, and therefore how would we pick? Well, which one should we have heard from?
Excuse me, gentlemen, it's not a dialogue, just if we could confine our remarks to the bill and through the Chair, please.
Of the responses from organisations, approximately 27 outlined their general support for the bill and 18 outlined their opposition. I would like to thank all of those individuals and organisations. Pardon?
How many did you hear from?
I'm going to outline who all we heard from in the course of my remarks. I would like to thank all of those individuals and organisations for taking the time to submit written evidence, and would like to thank all of those who attended committee meetings and gave oral evidence. Yep, go ahead.
And I thank the member for giving way. The member will know that myself and Pam Cameron did ask in the Health Committee for the evidence to be reopened, but the Chair will also agree some members were also allowed to give their views when it came to the severe fetal abnormalities bill as well. So could the Chair just maybe speak into that as to how many people were able to give their views during that evidence session?
Well, that was clearly as a result of a request from the sponsor of that bill that a particular individual who has taken a court case would be facilitated, and we felt that was appropriate and actually a compassionate thing to do. That doesn't mean that you can create then a precedent that you hear from 6,000 individuals whose evidence has made it very clear what their view is. So you're still left with the issue of how you would fairly address individual responses of 6,000 people. Go ahead.
Grateful to the member for giving way. I accept entirely the point that you can't ask all 6,000 people come in front of the committee. But could I ask, in relation to the clergy and lay people who are coming, who will represent thousands of people in Northern Ireland, why did the committee think it was not a good idea to hear from them?
The committee discussed that matter, and we agreed as a committee our approach to it, and we moved forward, and that is how. And those are all contained within the reports. The Hansards will be there. I would advise any of you who wish to revisit that issue to go and have a look at it. Okay, and move on. I would like to take the time to thank all the individuals and organisations for taking the time to submit written evidence, and would like to thank all of those who attended committee meetings and gave oral evidence. The committee was briefed by the bill sponsor again yesterday on the amendments that she is bringing forward. Claire outlined that she had worked with the Office of Legislative Counsel and the Department of Health to draft these amendments. While acknowledging that these amendments were brought late, the committee welcomes this joined-up approach and cooperative working by the sponsor and the department. And I do think that is a good example of a department working with the sponsor of a private member's bill in order to ensure it's as robust as can be. I would outline that the committee's clause-by-clause consideration of the bill was based on previously tabled amendments by the bill sponsor, and therefore does not take into account some of the amendments we have before us today. I would also note that the Deputy Chair, Pam Cameron, and Deborah Erskine did not take part in the formal clause-by-clause. So in relation to safe access zones, the committee heard evidence on the reasons why safe access zones are required. The Belfast Trust advised that since the beginning of 2021, despite lockdown and COVID-19 restrictions, there have been weekly protests from various anti-abortion groups outside their clinics here, including its College Street premises. The Belfast Trust advised the committee that protests cause considerable distress and anxiety to patients and staff. The Northern Trust also advised that it had to move the location of its clinic on 2 occasions, as there were concerns about the ongoing impact of personal and abusive protests on service users, and that there were concerns for patient and staff confidentiality. The PSNI advised in correspondence that in the 12-month period from January 2021 to January 2022, police were requested to attend 55 incidents related to this issue. Many of the organisations described the detrimental impact of the actions and behaviours of protesters on those accessing services, and highlighted the impact on particularly vulnerable groups such as minors and those attending services as a result of sexual assault. Some of the organisations pointed out that the actions and behaviours of protesters can cause distress to those who have suffered pregnancy loss and those who live with fertility issues. I would also outline that many of the organisations that opposed the bill also condemned situations in which women and staff were harassed or subjected to behaviours which would cause stress. They also stated that behaviours described were not the norm, and that protests that take place are often peaceful. However, I would outline that all members of the committee agreed that there is no place in our society for the harassment, abuse, intimidation of women and girls accessing health services, and that patients, staff and visitors should be able to access health premises free from harassment, abuse and intimidation. And I sincerely hope everyone in this chamber agrees with that. In terms of human rights, the committee sought the views of Human Rights Commission on the balancing of competing human rights, and in particular the right to privacy against the rights to expression, association and religion. The Human Rights Commission advised the committee that the bill engages Article 8, 9, 10 and 11 of the ECHR that require consideration. The Commission advised that none of these rights are absolute rights and can be interfered with and limited under certain circumstances. The Commission advised us that the European Court of Human Rights, in considering restrictions or limitations, has held that the restriction must be prescribed by law, have a legitimate aim under the relevant article, and must be necessary in a democratic society. To demonstrate that a restriction is necessary in a democratic society, it must also be proportionate. In light of this, the committee advises that in the case of safe access zones, there are legitimate aims such as the protection of health. Go ahead.
Did the Human Rights Commission also tell you about the cases which say that blanket bans are extremely dubious legally, and yet that's exactly what the committee is endorsing here?
The committee's advice is contained within the report and contained within the remarks I am making, as the member will know. In light of this, the Commission advises that in the case of safe access zones, there are legitimate aims such as the protection of health. Where protests are preventing access to necessary health care, causing distress or possibly leading to harassment of patients and staff, protecting their right to physical and psychological integrity under Article 8 of the ECHR is a very important factor. In relation to the amendments in Lascian Corlia, the committee is content to support Amendment 1 in the name of the bill sponsor. This amendment will ensure consistency with the language used in the Abortion NI No. 2 Regs 2020 and seeks to ensure provisions remain workable in practice. Therefore, the committee will be supporting Amendment 1 on the understanding that the committee's amendment to Clause 2 will not be moved as you have outlined. The committee is content to support Amendment 3 in the name of the bill sponsor, which provides greater clarity on how the Department will make a determination. The committee also supports Amendment 4, which clarifies the process around when a safe access zone is required to be greater than 100 metres and ensures that it maintains compliance with human rights. The committee supports Amendment 5, which seeks to remove subsection 4 of the clause, that it is a defence for a person to show that they did not know and had no reasonable way of knowing that the protected person was in a safe access zone. The committee supports Amendment 8, which seeks to provide clarity in relation to the role of the Department in publishing information on safe access zones. The committee supports Amendment 10, which is needed as a consequence of the bill's sponsor's intention to oppose that Clause 9 stand part. The amendment removes reference to the Convention. The committee supports Amendment 11 as it provides clarity in relation to the specific offence of recording a protected person in a safe zone as provided for in Clause 6(3). The committee supports Amendment 12, which provides clarity on the meaning of premises and what attending premises means within the bill. And I would just outline as well that the vast majority of premises will indeed be trust, and the operators in many cases will be trusts. So I wish to thank the bill sponsor for their engagement with the committee on the bill, and I would like to thank members for the work on this bill over a sustained period of time. I would also like to place on record my thanks to the committee team and the bill clerk for supporting members through scrutiny of the bill. And I also would like to thank the Department for working with the sponsor of the bill and the OLC for providing that technical support. So, Lascian Corlia, I make a few brief remarks now as Sinn Féin MLA and spokesperson for health. Sinn Féin support the Safe Access Zones bill, and we thank the sponsor for bringing it to the Chamber. Blocking access to a healthcare clinic is inhibiting a woman's ability to access the healthcare that she might need, and indeed that she is entitled to. Displaying graphic images, handing out leaflets and behaving aggressively towards women seeking treatment is unacceptable and should be unacceptable in any society, in my opinion. It's a violation of rights, and indeed it is indecent and it's disrespectful. Women who are accessing the services they need and workers who provide those services have complained of campaigns of harassment and intimidation that have left them distressed at an already anxious and stressful time. It is unthinkable that any woman in an already distressful and painful circumstances would be faced with such a violation of her humanity. This bill will create buffer zones wherein the rights of all will be respected. The right to privacy for women and girls and workers, the right to access healthcare, and the rights for protesters to protest and air their views, whatever that may be. That form of protest should, however, be respectful, and it should be free from the abuse that has been reported repeatedly to the committee. One's rights should not impair the rights of the other. I won't give way again. By moving protest from the immediate vicinity of the healthcare services, everyone's rights are protected. The protesters have their right to protest, but not to humiliate, not to verbally assault their targets, and women accessing treatment also have their right to privacy and safe, accessible healthcare to be protected. So finally, Lascian Corlia, it is time for the Department of Health to roll out the provision of safe and accessible services that women need and to which they are entitled and should be able to avail of.
I call Pam Cameron.
Thank you, Mr Deputy Speaker, and I welcome the opportunity to speak in this debate.
With the exception of Amendment 6 in the name of the member for North Antrim, I will not be supporting any of the amendments moved at consideration stage. I do not support this bill, and my party does not support this bill. I voted against it at second stage and clearly outlined the concerns with this legislation during the Health Committee consideration. We also ensured these concerns were recorded within the Health Committee's report. Mr Speaker, this is not because I believe patients, staff and visitors should be subjected to malicious or abusive behaviour. All patients have the right to access healthcare free from abuse and intimidation. All patients should have access to an environment where they feel safe. The activities against anyone entering or exiting health premises which are clearly harassing and criminal need to be dealt with. However, I am deeply concerned that this legislation and these amendments will not have the desired impact. The criminalisation of direct or indirect influence in Clause 6 of this bill is broad, sweeping and vague. Mr Speaker, under the framework proposed in the bill, there would be no requirement for influence to be undue or unreasonable. Established legal principles have been set aside out of convenience. This is reckless. It is in breach of Article 9, 10, 11 of the European Convention on Human Rights, which establish the right to protest and freedom of religion. Its implications would set a dangerous precedent for restricting other forms of expression in the public sphere. The provisions of the bill would almost certainly be subject to protractable legal challenge, and this would have serious implications for the taxpayer and do little to improve outcomes for those with legitimate grievances. We want all those seeking health services to feel safe, to be free from abuse and intimidation. However, this bill does not distinguish harassing, abusive or criminal behaviour from influencing behaviour. The question we need to ask ourselves is how this Assembly can pass legislation that properly balances competing rights, that is workable, lawful and avoids falsely raising expectations of women and staff. That won't be subject to immediate legal challenge. I am disappointed that neither the Committee nor the Minister of Health have pushed back against the rushed and dysfunctional drafting of this bill. The PSNI have said enforcement would require continuous physical police presence. And where is the Minister of Justice concerned for the potential implications for policing resources? Consultation has been limited and is over 5 years old. Mr Speaker, legitimate concerns of patients and staff should be addressed, but this should be primarily through a comprehensive review of the law on harassment. And sadly, there has been no willingness among the other parties to even consider this as a viable alternative. With these overriding concerns on the record, I now want to address the amendments being moved.
No, I take your point, and one of the amendments I was bringing forward was to sort of try and support those people who did want to come and protest, to give them clarity around that. But you talked there around reform of the harassment laws. I don't see any amendments brought forward by your party in relation to this bill that could have addressed the issues that you're raising here today. Why not?
I'll continue after that intervention. Thank you, Mr Speaker. While these overriding concerns on the record are now on the record, I want to address the amendments being moved by the bill's sponsor and representatives of the Alliance Party. Amendments 1 and 3 amend clauses 2 and 3 and would grant an unqualified right to premises where abortions take place, as well as those which provide information, advice or counselling to become a protected premises. The only requirement appears to be that they notify the Department. The original stipulation that the Department must be satisfied if it is reasonable to make premises a protected premises under Clause 3 is removed entirely. We cannot support these changes. Automatic entitlement, seemingly with no recourse to the Department to challenge a notification, does not seem responsible or proportionate. In addition, it fails to provide any ability for a consideration on a case-by-case basis of whether the creation of a zone is rights compliant under Articles 9, 10 and 11 of the Convention. Amendments 4 and 12 in the name of the bill's sponsor are more significant and deal with the extent of protected premises. Clause 5 is replaced by a stipulation that the safe access zone consists of protected premises themselves and the public areas within 100 metres of the entrance or exit of those premises. This could then be extended by a further 150 metres on request of the operator of the premises. Mr Speaker, under this framework, there seems to be no authority for the Department to ensure that the extent of a zone is commensurate to its location or circumstances. It would impose a blanket approach, regardless of whether the building or facility is situated in a congested high street or city centre or on the health and social care estate. The Department's role would simply be to maintain a register of zones, a gatekeeper, if you will. This in itself, I believe, is deeply problematic. I am open to correction, but I believe the bill's sponsor previously opposed a prescriptive approach to the extent of safe access zones, and I'm not sure what has changed. The reality is that the amendments 4 and 12 are littered with contradictions and confusion. New clause 5 defines a public area as a place to which the public has access without payment as of right. Does that mean hospital car parks that charge entry would be discounted from the calculation of a 100-metre buffer zone? If protesters congregated in that area, would they face prosecution or not? To go one step further, Amendment 12 frames premises to mean the land on which they are situated. This leads us to ask, does a safe access zone start at the entry to hospital grounds or at the front door of the hospital? How can we expect the public to abide by these provisions when the bill is unclear and poorly drafted? Moving on, Amendment 5 removes the defence for protesters to show that they did not know and had no reasonable way of knowing that a protected person was in a safe access zone. And although I can absolutely understand the intentions of the Amendments 7 and 9 in the name of Paula Bradshaw, which require signage marking out safe access zones, I am concerned that this would not result in a safe environment for patients or staff, but rather a conspicuous signposting to the entrance of such services, essentially placing a spotlight on any individual that enters the zone. I am concerned that such a proposal would actually single out patients and staff rather than single out the perpetrators of abuse or harassment, and this could have an effect on increasing conflict and unproductive interactions. Have patients, staff or local businesses been consulted on whether they feel signage would be appropriate or helpful, I would ask? I cannot support these amendments, and my party cannot support these amendments. We feel it would be wrong to dilute what are already very limited protections contained in the bill for protesters, whilst the indiscriminate criminalisation of influence remains at the heart of Clause 6. I am supportive of the Amendment 6 in the name of Jim Allister, and this would ensure that within the context of the original provisions of the bill, within 8 weeks of notification, the Department would designate an area as a safe access zone only after it has given due regard to the right to manifest religious belief and the rights to freedom of assembly and expression set out in Articles 9, 10 and 11 of the Convention, and in particular the right to protest. This obligation to account for such freedoms is glaringly absent under the proposed amendments. Amendment 11 tightens up the parameters of unlawful recording for the purposes of the offence created in Clause 6. However, the reality is that it misses the elephant in the room, namely the ambiguous and open-ended approach to the offence of direct or indirect influence within the same clause of the bill. Mr Speaker, on balance, I feel these amendments would exacerbate the concerns regarding the disproportionate impact of this bill on freedom of expression and the right to protest. There is a real risk that the effect of these provisions, particularly if amended, would be to simply displace the bulk of protest activity rather than deal specifically with a minority of individuals engaged in malicious and abusive behaviour. As iterated through our submission to the committee report, this would only serve to present false hope to women who hold legitimate concerns about behaviour directed towards them. And I would urge members to reflect upon the wide range of concerns that have been expressed in relation to the rushed and careless drafting of this bill, and to consider revisiting these matters in a new mandate. Thank you.
Mayor Colin McGrath. On Cancha, I call Colin McGrath.
Thank you very much, Mr Deputy Speaker. And I'd like to start right from the outset by saying that this is not a debate on abortion. Nowhere today are we being asked to debate the legislative position of abortion. Nowhere are we being asked to compromise any of the deeply held views and principles that people may have on that. And anyone who tries to paint today as a picture today of being a debate about abortion itself is playing politics with the emotional and psychological well-being of those women who do access these services. But, Mr Deputy Speaker, what we are debating is a series of amendments that have been flagged up as a result of the progression of this bill as it has moved through the Health Committee. They are mostly technical in nature. However, they do tidy up some of the clauses, and I am grateful to the bill's sponsor for her work on that to clarify those matters. So, for instance, Amendment 4 seeks to establish the set of parameters of a safe access zone and creates a 100-metre area that would be protected. And I believe that this is helpful, as it allows a very defined area of protection for those that are accessing such services. There is also the flexibility, if needed, to increase this distance to 150 metres. Amendment 7, that has been provided by Ms Bradshaw, details the need for signage in certain areas which could identify the people that are in a protected area. There was much conversation about this amendment as it relates to one specific area, which I think needed to be mindful and sensitive, and we would be happy to support. It was particularly detailed to us by the PSNI, who were concerned about their ability to enforce the zones if there wasn't any clearly identified signs that indicate that it was an actual zone. Amendment 8 necessitates the publication of protected premises and safe zones, thereby ensuring the transparency for the public in relation to the protections that are afforded to the premises. I would draw particular attention to Amendment 11, and I would say to the bill sponsor the importance of this one. Regardless of one's view on abortion, it is not acceptable to record sounds or images of a woman who is trying to access these services and then share them on social media. It is not acceptable to record members of staff who are working on the premises, and it is not acceptable to record anybody else that is going into these premises. And as I think I'm nearly sure in saying that the services to which people have some concerns about are not the only services that are available in these buildings. So people could be going to these buildings for other reasons, but we're being subjected to all of the concerns that people had raised, especially the police, who said that they had to be called on quite a number of occasions, and there was always the issue that that could have been for people that were going into the building for entirely different reasons. In conclusion, the bill we are debating does not impede anyone from objecting to abortion services, and therefore the SDLP can support the bill and the amendments provided by the bill sponsor and Ms Bradshaw, and will oppose Amendment 6 from Mr Allister. Thank you.
I call Alan Chambers.
Deputy Speaker, as a member of the Health Committee, I certainly refute any suggestion of a biased approach been taken by myself during the process. Scrutinising this bill was a lengthy, a difficult and indeed at times an upsetting task. Now, my party will be supporting the sponsor's amendments today, which I understand have been worked through between her work and the department. We will not be supporting Amendments 7 and 9, which put a responsibility on the department in relation to signage. We have concerns around those particular amendments. Mr Deputy Speaker, when I made my first contribution in this House some months ago on this bill, I made it clear that it was not to be viewed through the lens of being a pro-life or a pro-choice debate, and that fact remains. The subject of abortion is a matter of conscience for the Ulster Unionist Party Assembly team, but this bill falls outside the scope of where an individual stands on the subject of abortion. At best, it is misleading for some people to try and make this bill into another debate on the emotive subject of abortion. So how my party votes in this bill should not in any shape or form be viewed as representing either my own or any of my colleagues' position on the subject of abortion, either pro-life or pro-choice. However, it still remains a matter of conscience, and that will not change. The purpose of this bill is to provide a degree of protection for any vulnerable woman seeking advice or guidance at an abortion clinic. They may be at the lowest point of their life, unable to share their fears or concerns with even their most trusted friend or a family member. All of the correspondence that I have received about this bill has been from those on the pro-life side who are opposed to it. This fact tells me that in the eyes of many, the topic has been reduced to a pro-life, pro-choice argument that it clearly is not. Many who have contacted me, and I fully respect their motivation, have spoken about those who are following the words of Scripture and taking part in a protest that will lead to them being criminalised. Unfortunately, we have heard during our evidence hearings in the Health Committee, some protesters, maybe only a small number, are not only targeting those women heading into a clinic, but also those who actually work in these clinics, and worse, other members of the public entering such a building in pursuit of other business. And this may include children. The protesters take photographs, they shout loudly. So Amendment 11, I welcome it, addresses the aspect of protesters taking photographs or using videos. I'm sure that we would all acknowledge that this sort of behaviour is unacceptable. The bill allows for a police officer to direct a protester or a suspected protester to leave the safe access zone. They then have the power to remove the person from the zone if they do not leave. At this point, no one has been arrested nor attracted the potential of a criminal record. And we've heard from speakers that there are harassment laws from so many years ago that could deal with this situation. That's fine. But even if you breach those harassment laws, you will attract a criminal record. So it's not the harassment law, or it's not this new law that will make you a criminal. It's your actions that will make you attract a criminal record. The other issue that has arisen in correspondence is the human right to protest and the right to freedom of speech. Those rights also come with responsibility to respect the human rights of others. Those seeking to attend a clinic also have human rights in relation to seeking medical advice, and their rights are equally worthy of protecting. The bill has sought to find a balance between all these competing rights. The right to protest directly outside a clinic will simply be displaced to a point 100 yards away from the clinic. It will not stop you protesting. The right of an individual to enter a clinic for whatever reason will also be protected by the bill. It will prevent any individual being intimidated or subjected to behaviour that would cause them to feel either threatened or fearful. I believe the bill, as amended, respects everyone's rights, be that to either peacefully protest or to enter a building without fear. Thank you, Mr. Deputy Speaker.
I call Paula Bradshaw.
Thank you, Deputy Speaker. I will confirm that I'm not going to be moving Amendment 7 nor Amendment 9, as the Health Minister has written to the committee members, and the bill sponsor outlined what that meant in practice at our special Health Committee meeting yesterday. I do welcome what was in the Minister's letter in his assurance that he will be developing a policy statement setting out how these zones will be implemented. So I will be supporting all the amendments brought forward by the bill sponsor, including those with reference to clauses not standing part, will be opposing all others. Mr Deputy Speaker, Amendments 7 and 9 were essentially the same amendment, and it is worth emphasising why we still need to add clarity to the original bill around this area. This follows on from evidence, as my colleague Colin McGrath just outlined there, given to the committee, particularly around the relative ineffectiveness of the law as it currently stands. It bears repeating and emphasising that safe access zones exist elsewhere. In the words of the Queensland Law Reform Commission, they are to protect safety and well-being and respect privacy and dignity. In an unamended bill, I felt the description of law of the zones themselves was clear. However, and similar to the law already adopted on the Isle of Man in 2019, Usefully, other amendments have now even further strengthened this description, including with reference to the abortion regulations of 2020. What concerned me in our committee deliberations was that the ability to enforce this law when in distress was clearly intentional, was being caused, may have been limited by the bill as it initially stood. To be clear here, we are not talking about reasonable protest, which is legitimate, but about behaviour likely to traumatise or further traumatise. When people are accessing health care... Yes, I will.
Where in the bill, in clause 6, does it say that the criminality is limited to circumstances where the behaviour is likely to traumatise? It says no such thing. It is all-embracing of anything likely to have an effect of influencing, no matter how innocuous that might be.
Well, we took plenty. Well, I personally spoke to people who have been traumatised by accessing services, and we heard from the chief executives of the Trust who even talked about how their staff felt traumatised having to run the gauntlet through these protesters. So when people are accessing healthcare, Deputy Speaker, they should not have to run this gauntlet of hate and harm. My intention was and is to ensure this legislation is clear about where this gauntlet is. We need to be in no doubt about the right to protest. Like any other right, however, it is not absolute. It comes with a responsibility, and essentially that responsibility is to behave reasonably. No one can argue that it is reasonable behaviour to target women in a way designed to make them feel angry, uncomfortable, traumatised, scared, intimidated, upset, inadequate or unsettled by subjecting them to a torrent of public abuse as they exercise their right to access health care. Mr Deputy Speaker, the bill empowers the police to enforce safe access zones, and my concern was that the legislation initially did not make it sufficiently clear where these applied. During 2021, the police attended over 50 incidents at premises which would be protected by this legislation going forward. Before that, in the most well-known case, police were deployed at Mary Stopes daily and reported 85 crime occurrences, resulting in just one successful prosecution. And even then, the conviction was overturned precisely because the judge could not be clear that the unpleasant behaviour constituted criminal harassment. This is exactly why this legislation is necessary, but it is also why it is essential to be clear as possible about what precisely that entails. And I would repeat that I welcome the Minister's commitment to looking further at this through a policy framework. So, turning to evidence, Mr Deputy Speaker, evidence was brought to the committee emphasising that there would be a potential defence under the legislation as it stands, that those engaging in abuse did not know that they had approached a protected person. This was raised on the definition of protected person, but in my view it also emphasises the need to be clear about where the offence applies. The reason for this is not just about legal defence in the event that someone is charged with an offence. It has to do with knowing when the police should be called, and indeed about providing clarity to prevent offences from occurring in the first place. In other words, what I want to ensure is that there is no uncertainty, and that where there is space for reasonable protest, that is defined as well. This is to reduce the potential impact on police resources, and most of all to reduce the likelihood of offences occurring at all. The distinction between reasonable protest and forcing people to run the gauntlet of hate to access health care will need to be very carefully defined going forward and established, not just in law but also on the ground. So in conclusion, I hope that the bill, as now strengthened by these amendments, can now proceed with this uncertainty reduced. I support the amendments of the bill sponsor, and just would like to thank her and the committee staff for their work during the consideration stage. Thank you.
Agus na sírim sir Emma Sheeran hon cainse call Emma Sheeran.
And I'm speaking, I support the premise of this bill, as I stated during the last consideration stage, and can confirm that Sinn Féin will be supporting most of the amendments and clauses made in the name of the bill sponsor, and voting against the amendment in the name of Jim Allister. I think it's Amendment 6. This bill for us is about righting a wrong. It tackles violence against women and complements a lot of the good work that has been done or is being progressed currently in this Assembly during this mandate. Obviously, we have a high proportion of female ministers at the minute in this mandate, and you can see the impact of that through a lot of the work that we have done to tackle misogyny. And my own party colleague, constituency colleague Michelle O'Neill, when she was the Minister in TEO, led on the strategy to tackle violence against women and girls, and we want to see that progressing. But we've also had bills from across a number of ministers, including the Justice Minister, around tackling stalking, revenge porn, upskirting, down-blousing, coercive control, sex trafficking, and issues that have for decades and centuries affected women and have been let progress. And this particular bill works alongside those bills to tackle that and to address misogyny and address the root cause of what is effectively violence against women. These so-called protests are acts of aggression targeted at women, women whose circumstances the aggressors neither know nor understand. That children, people living with disability, staff members are caught in the crossfire, exposed to graphic and harmful imagery without any regard for their personal circumstances is evidence of the intent of the protest organisers. Ireland, as a country, has a shameful, tragic history in terms of how we've treated women and girls in pregnancy. We had Magdalene laundries, mother and baby homes, unmarked mass graves, secrecy and shame, commentary and judgment. And I don't understand why other people's pregnancies are so interesting. I don't understand why another woman's womb is cause for concern to a random stranger who doesn't know anything about her life. But even beyond criminalisation, we've kept a lot of the gender norms and the social stigma that have acted to pressurise and shame women down through the centuries. And as young people, we are all aware of what's expected of us, and we've heard the remarks and the commentary. No babies until you're married. Once you're married, babies right away. If not, why not? Is something wrong? Are you prioritising your career? Are you prioritising some other aspect of your life? And that all carries shame along with it. Yet we don't have funding in this place for the 3 cycles of IVF that we were promised as part of NDNA over 2 years ago, a letdown for those struggling with infertility. And the absence, up until this point, of safe access zones outside clinics is a similar dereliction of duty towards those women and couples who are struggling with infertility. I will.
Agree with me that it's not just those women who are accessing healthcare at that point, but also those women who maybe have experienced miscarriage, who do see the graphic images, see the protests, and it can be re-traumatising for them.
Thank the member for her intervention, and I would agree with that point, and I was just coming on to that around the fact that women who are perhaps undergoing treatment relating to fertility or have suffered an ectopic pregnancy, a miscarriage, the loss of a child, a stillbirth, are going to be traumatised when they're exposed to that imagery, and for anyone to defend that, I think, is cruel and insensitive. It's equally heartless, in my opinion, to impose such pressure on children who may be accessing speech therapy, women who are accessing routine contraception, staff members trying to do a day's work, and perhaps most importantly, the women who are accessing abortion services that they are entitled to in this state under the law. It's been said already by many across this House, this is not about people's views on the topic of abortion. We live in a state that is supposed to deliver healthcare free at the point of delivery without discrimination or fear of favour, and people should be entitled to access health without being traumatised or pressured or catcalled on their way into that particular place.
I now call Deborah Erskine.
Thank you, Mr Deputy Speaker. I have thought a lot about this particular bill and indeed the consequences of it, and I welcome the opportunity to outline my viewpoints on it today. And I know this bill will be of interest to many in the public domain. And from the outset, I will make it clear that, as outlined by my colleague Pam Cameron MLA, with the exception of Amendment 6 in the name of the member for North Antrim, I will not be supporting any of the amendments moved at consideration stage. And like the member for North Antrim, I am in agreement in opposition to the clauses of this bill, and I will outline why. Mr Deputy Speaker, I would also like to place on record that my voting on this issue has been consistent and clear. And unfortunately, throughout the course of this bill, passing through the committee stage and at different stages through the House, there have been those in the public domain who have spread false and inaccurate information in relation to my voting record, which has been deeply upsetting and designed to wreck my character and my deeply held views. And I hope that those listening to this speech today will realise the consequences of spreading inaccurate information. Now to the bill in question. I believe that there has been inadequate time to properly consider the bill, and indeed myself and my DUP colleague Pam Cameron MLA made this view clear in the committee. In truth, the fact that we did have the bill sponsor at the committee meeting yesterday to discuss her amendments and yet be in the chamber today debating this legislation speaks to this. For example, we've not been able to properly consider the consequences that it may have around surrounding businesses if a safe access zone were to be implemented, or indeed look at best practice elsewhere. Yes, I'll give way.
Thank you very much for that. And just on that point that you're making, that there hasn't been enough time. I mean, this bill began work in this institution in 2016. We had 3 years with no assembly, and it was finally introduced in September last year. And I note that your party colleague has introduced a bill on the 5th of July, just before recess. This one was introduced just after recess, but your colleague's bill has gone through the further consideration stage, and you're saying that there wasn't enough time for this bill, but there have been for other bills. And the reason that I was at the committee yesterday wasn't because of a timing, it was due to the availability of the OCL and the departmental officials. Thanks.
And I thank the member for her intervention, but a lot has changed since 2016. And I would like to see an updated consultation come forward. I would like to see some updated information that we could properly look at this bill in the round now when we're looking at it in 2022. Yes, we have heard very important evidence which cannot be diminished, and it is particularly distressing to listen to some of the stories that we have heard in the Health Committee. And I do recall evidence in particular of a cancer patient who was attending a clinic not for an abortion but for advice due to the nature of their cancer, and abuse was hurled at them. And I do question care and compassion in relation to those particular cases, because not all cases of protest, however, not all cases of protest create distressing situations such as this. And we have to strike a balance in relation to freedoms of speech, which is enshrined in law. Article 9, 10 and 11 of the European Convention on Human Rights establishes the freedoms which underpin the right to protest. I also wish to point out that it would be incorrect to suggest that wrongdoing is mainstream within the pro-life community, or indeed even mainstream within protest activity by pro-life advocates. Therefore, I do categorically condemn actions by a small minority of individuals in the vicinity of these settings that are malicious and reasonably regarded to be criminal in nature. Given the threats made to staff, which resulted in 2 members being unable to be identified during evidence sessions in the Health Committee, I would like at this juncture to place on record my thoughts with those working in health care premises who are fearful and intimidated by simply going to do their job. In terms of the implementation of this bill and enforcement, I do have concerns which I feel have not been addressed. The police stipulated that it would be difficult to enforce this piece of legislation as it required continuous police presence. Now, when you look at that issue alone, and the fact that there may be policing cuts on the cards given the budget to the Justice Department and policing numbers, we must ask the question, how will this legislation be enforced without proper resources on the ground? And I did state in the Health Committee meetings that surely the Justice Minister must have some role to play in relation to this piece of legislation. Yep.
For giving way, and she makes a very important point. Not only has the Chief Constable recently talked about the budget pressures and the effect that will have on his resources, We haven't had the numbers of police that were promised and to be delivered under NDNA. And when you talk to the police, as I do as a Belfast representative, they will tell you they're already hugely overstretched in terms of the current policing of the city centre, where there are huge problems around drugs and solvent abuse and so on.
The member is absolutely correct, and that has been raised numerous times in this House over the last number of weeks in relation to the problems that exist in policing, and it will be mostly concentrated in Belfast as well. So I thank the member for his intervention. It is likely that these provisions, if ratified, would be subject to legal challenge with implications for the taxpayer. You see, Mr Speaker, I know I've only been an MLA for a short period of time, but I am not naive, and I believe private members' bills should not be a tool to gain votes at the ballot box or simply for a line in election literature. Legislation must be there for the purpose it is intended for. It must do exactly what it says on the tin, and I do not believe this bill does deliver that as drafted. It raises expectations for staff in such facilities, the service users and the visitors who have legitimate concerns over their treatment outside the doors of premises. Persisting with unbalanced and unworkable legislation is a failure upon us as the lawmakers. My colleague Pam Cameron has set out the stall in relation to each of the clauses. However, I do again want to bring attention to some of the points. I'd like to draw your attention to Amendment 4 and 12. I believe Amendment 4 is significant and points to a U-turn on behalf of the bill sponsor. At the beginning, Ms Bailey was against the idea of including any prescribed distance on a safe access zone. Now we see distances included, and that there is no provision for the Department to consider whether the distance is appropriate to the circumstances. So let's take, for instance, Belfast City Centre. What would businesses have to say about the fact that they may be included within a safe access zone? Would they be aware? Does influence come under that? Will it turn customers away from going near that area as protesters may be displaced? I know that Amendments 7 and 9 now won't be moved, as Ms Bradshaw has indicated, but I do want to give my views on them. In relation to signage, does this further add to the lack of desire from someone going into a zone and affecting businesses surrounding? Whilst I understand the intention and the motivation behind these amendments, as it removes the defence of lack of knowledge on where a zone is situated, it may also draw attention to anyone entering that zone. It is therefore has a counterproductive effect. Has the sponsor consulted with the PSNI to gauge what extent signage will actually make enforcement easier, and perhaps they could deal with that specific question in time? In terms of Amendment 6, in the name of the North Antrim member, I wish to thank him for tabling this amendment. This provision would ensure competing freedoms are balanced in the implementation of the bill, whilst taking a proactive approach to reducing legal liability for the Department and potential cost to the public purse. Yeah.
I fully agree with you that none of us in this chamber want to see police time, or court time for that matter, tied up with the offences. But as political leaders, should we not be encouraging people to not protest and to have their silent prayers elsewhere, where they wouldn't be coming into conflict with the police and those people who are trying to access healthcare? Do you not think that would be the responsible position, to encourage people not to protest where it could cause those difficulties for the police?
And I ask the member, do we not have freedom of speech in this country? Do we not have the right to protest?
The member for South Belfast raises that point, because that's a salient issue that's being discussed at Belfast City Council, where people who are street preachers and evangelists in the city centre, particularly Cornmarket, are being harassed by people who are opposed to their views, their religious views. And indeed, I had an old gentleman who for years has been giving out literature in St George's Market, who was refused the right to do that, and I took his case up, and that was reversed. That's the sort of freedoms that this country should want to see in terms of religious freedom in this city, our capital city. It's an appalling remark from the member for South Belfast, I must say.
Remarks were in reference to the police having to intervene, take up valuable time away from dealing with other crimes. That was the point of my intervention. Thank you.
And again, I point out freedom of speech is very important. The right to protest is very important. And I think that all of us in this chamber should uphold the right to protest and freedom of speech. I would like to move on. Overall, I'm not convinced that the bill does actually deal with the matter in hand. It is not about abortion, as has been pointed out by some members in the chamber today. In fact, the issue is around some of the malicious practices that sometimes and unfortunately has operated in these areas. However,
members wishing to have a chat maybe should go outside. Okay, thank you.
Freedom of speech. However, in the same token, it does not mitigate for those who wish to carry out peacefully protest, or indeed, for instance, speak to a loved one who is using an abortion service before they enter the premises, who may want them to rethink, as influence is included within this bill as an offence. Influence can be open to interpretation, and the inclusion of it is, I believe, dangerous and has ramifications for a number of groups and people. I believe the bill will displace the problem elsewhere. I believe the issues can be rectified through looking at harassment laws and strengthening them, rather than create a rush-through piece of legislation. I would therefore strongly encourage members to consider carefully this legislation, which will and may need revisited in any future mandate.
Thank you, Sir. Liz Kimmins, one kind to call Liz Kimmins.
And I think others will know this is a very relevant issue to my own constituency, where ironically, as we speak, there has been protesters at Daisy Hill, my local hospital, from early this morning. A weekly ritual, like in other areas, that has been causing huge distress and anxiety for many women as they access abortion services or indeed other healthcare services for the better part of 2 years now. Mr Deputy Speaker, over the last number of months particularly, this Assembly has stood united in our commitment to tackling violence and abuse against women and girls. Yet some members stand opposed to this bill, which will protect women from what is undoubtedly the targeted abuse of women. And we can't pick and choose what types of abuse we think women should be protected from. You either support the protection of women and girls or you don't. And I disagree with the view that this is censorship as well. I fully appreciate the right to freedom of speech and the right to protest, but where this is having such a significant impact on so many people, we need to put in place appropriate protections, because it is about balancing the rights of everyone. I've read the report by the Health Committee and the evidence given by the many stakeholders, which corroborates the fact that these protests have real impacts on patients, staff and members of the public, which we've been saying for months and months now. And sadly, those who are so vehemently opposed to this bill fail to address in some of their comments. For those who wish to protest, they can still do so. No one is taking that right away from them. What's being proposed here is not about creating a one-world view, as some have alluded to, nor should it create further pressures on the PSNI, as the previous member had mentioned. And I think the member for South Belfast was referencing this as well. When people know what the legislation is, they're more likely to say, right, well, I can't do that. It's like we know when there's a double yellow line there, we can't park there. So we don't need police to come out every single time we think about parking there. So I think when you put it in that sort of context, it kind of supports what the other member was referring to as well. Safe access zones are about creating safe and neutral spaces to enable women who are incredibly vulnerable to access healthcare services free from intimidation, free from harassment and free from abuse. And regardless of what the intention of those who are protesting may or may not be, the language, the imagery and the behaviour that has been used at these protests, and is well documented, that I might add, has and will continue to have a very damaging and distressing effect on women if protections aren't put in place. Women deserve better. Women who have been raped, women who have had the devastating news of a fatal condition of their unborn child, women who, for their own personal reasons, cannot continue with their pregnancy, women who are accessing healthcare or who work in these healthcare sites and who have maybe suffered pregnancy loss or are experiencing fertility issues. They all deserve better, and we have a duty to support and protect women who are going through this very difficult and often life-changing experience. So nobody should be faced with this type of behaviour when accessing healthcare. And I welcome Amendment 4 in particular, which further clarifies the distance allowed for establishing a safe zone, as this is a concern that was brought to my attention, particularly in relation to Daisy Hill, as it wasn't clear initially if the safe access zones would be in place at the front doors, would be relevant to the front doors of the building, or if indeed at the entrance and exit to the site as a whole, as that is currently where protests take place. And without this clarification, it may have been the case that the bill would have consequently had no impact in situations like or at Daisy Hill. So, Mr Deputy Speaker, of all the issues I have dealt with in my time as an elected representative, I can say wholeheartedly that this is without doubt one of the most important to many of the people in my constituency who, regardless of their views on abortion, as others have said, have expressed their dismay at these protests at our healthcare sites, particularly Daisy Hill, which is held with the highest regard by us all. And it's been widely recognised that the behaviour of many of those protesters towards women and towards staff is unacceptable. So I'm pleased this bill has now reached this stage, and as someone who is incredibly frustrated by the lack of clear responsibility for dealing with the range of issues emanating from the protests, I hope members will support it to the next stage and to its conclusion, to finally provide the Department for Health with the ability to protect its service users and staff from this trauma in future.
I now call the sponsor of the bill, Ms Claire Bailey.
Thank you, Deputy Speaker, and thank you to everyone so far as well. And I suppose it's to be expected that some members have taken the opportunity to use this debate to rehash views on abortion rather than what is actually happening on our streets, outside clinics and charities. And what is happening is the deliberate campaign of harassment and intimidation against women seeking to access services. For no other health service would this be tolerated, but because of views on abortion and reproductive health care, we turn a blind eye to this. This bill seeks to allow safe access to sexual and reproductive services. And on that one, I will quote from CEDAW, and I think that I have done this before in the past. CEDAW, who carried out a full state inquiry on the UK, something they do very, very seldom, and found in Northern Ireland that in their 2018 UK state inquiry carried out, they found that the UK's failure to protect women from harassment while accessing sexual and reproductive health services and information counted to a breach of their Article 10 and Article 12 rights under CEDAW. So therefore, women are discriminated against in accessing specific educational information to help ensure the health and well-being of families, including information and advice on family planning. And that's the context of this bill. But today, we were to be here to discuss and debate the amendments put forward to the bill, and not really in opposition to abortion. So I do find it confusing to hear that the DUP will not be supporting the bill, given that DUP councillors in Belfast City Council supported a motion brought by Green Party councillor Anya Grugan back in 2021 in June, and the DUP councillor Gareth Spratt stated, and I quote, "Our support for this motion does not affect our individual pro-life positions on this matter of conscience." Now, while acknowledging liberty of speech and the right to protest, he also stated how, and I quote, "We must ensure protection of already vulnerable women and the prevention of trauma." And DUP councillors in Newry, Mourne and Down Council also supported a motion calling for exclusion zones like those proposed here. Yep.
Got stuck there. I thank the member for giving way. My problem is with how this piece of legislation has been drafted, and I outlined in this chamber today my concerns in relation to how enforceable it will be on the ground and how it will work in practice. That is what I have stated in the chamber today. So my concerns are centred around how this bill is actually drafted and how this legislation will actually have outworkings on the ground.
And before her clarity on that one, during the consideration stage, you've opposed the bill today, saying that you cannot understand the rationale of some amendments before us. And, Deputy Speaker, I think it's fair enough to say that there would be no amendments to this bill that would be accepted, as they just don't want to see the bill pass, exactly like Mr Allister, and he's very upfront about that. And addressing concerns around automatic setting of zones and the publication of such that have been raised, I think it is unfortunate that the Minister is unable to attend today, but I do want to make members aware that both I and the committee have been given every assurance from the Minister that he will address this. And if it's okay, I'll let you know that the Minister has stated that his department will develop a policy statement if this bill is passed, setting out how it intends to implement the requirements around safe access zones, including guidance to operators of HSC premises and display of clear and appropriate signage at protected sites. So again, I hope that will go some way to giving reassurance to those who shared any of those concerns. And the Health Committee's call for evidence on this bill closed, as we heard, back on the 12th of November 2021, and it was a call of evidence that led to the submission of 45 written responses from organisations and 6,412 submissions from individuals. And I do note the high number of responses to the call for evidence, and I'm pleased with the level of engagement, particularly from those impacted sectoral bodies, as it will undoubtedly help me and us, if possible, improve the quality and robustness of this final piece of legislation. And while I note the volume of responses from those opposed to the bill, these responses tend to rely solely on the rights of those engaging in activities outside sexual and reproductive healthcare clinics, such as freedom of assembly, freedom of speech, etc. But these are not absolute rights. However, and it's not sufficient to say that because this bill will restrict these rights in certain circumstances, that it is therefore not compliant with human rights. The reality is much more nuanced than that just simple binary understanding, whether that be deliberate or not. It requires a balancing of rights. And indeed, as the Northern Ireland Human Rights Commission highlighted in their evidence session, the court in the Ealing case found that had the local authority not taken action to ensure access to the clinic, they would have been breaching the human rights of those
members,
patients.
there's a conversation going on which is audible up here, so if members wish to have a conversation, please do so outside. Thank you. Please continue, Ms. Bailey.
Thank you, Deputy Speaker. Certainly.
I've listened with interest to a number of occasions about the references to Articles, I think, is it 9, 10 and 11. But as you have stated, and just expand on that, in each one of those freedoms and each one of those articles, it also clearly states that if in the exercise of them an individual is breaking public order or is impacting other rights or is impacting public safety, then consideration can be given to providing a way of restricting those rights. It's quite clear in there that if somebody breaks those rights, that they can be held account for that. Would you agree that that means that what's contained within this bill actually is compliant with those articles?
Thank the member for that, and he's absolutely right. There are caveats within those rights, but those caveats need to be prescribed by law, which currently they're not, which is exactly what this bill seeks to do. So rather than wipe out protest, as some think it's seeking to do, it doesn't. It simply prescribes in law, under human rights articles, the balance of those competing rights. But going back to the Ealing case that was taken, where it was found that had the local authority not provided zones, that it would have been the authority that would have been in breach of the human rights to those patients needing access to abortion services and information. And given the findings of the CEDAW UK state report that I've already referenced, the overwhelming evidence provided by the Trust to the committee and the testimony of service users and staff included within many of the responses to the call for evidence, it's clear that there is an urgent need for intervention like that proposed in this bill in Northern Ireland at this time, in order to ensure that safe access to legally available services and information is permitted. And I have listened intently to the Health Committee's evidence sessions over the last few months, where they have heard oral evidence from the Northern Ireland Human Rights Commission, the Health and Social Care Trusts, the Department of Health, the Police Service of Northern Ireland. I've been happy to engage with the committee, the Department, the PSNI, the Human Rights Commission, the Attorney General, the Office of Legislative Counsel as well, in order to help inform my decisions around what amendments are needed to give effect to my intention around this piece of legislation and ensure that it is workable and effective if passed. The Northern Ireland Human Rights Commission, the Trusts, the Department of Health all made it clear in their oral evidence sessions that there was no alternative legislation or regulation already in place that could deal with the problem. Harassment laws required a course of conduct to occur before action can be taken. There are two issues with this in the context of what is happening outside sexual and reproductive healthcare centres. First of all, a patient attending a sexual and reproductive healthcare centre for the purposes of accessing abortion services in all likelihood will only attend that centre once. And this debate had been had during consideration stage as well, but I feel the need to repeat it since it was brought up again. So the offending behaviour is unlikely to ever be considered a course of conduct, as it will only happen on one occasion. Certainly.
Harassment, of course, is only one issue. There is the public order, which makes it an offence to use written material that is threatening, abusive or insulting. Under the same order, disorderly behaviour is a criminal offence, and there are also other provisions to condition public gatherings. So it's not just about harassment. There are multiple opportunities to deal with untoward and unsuitable behaviour.
The member for that, and they're all deemed insufficient and inoperable under these circumstances, which is exactly why the behaviours and the distress is happening, which is exactly why the committee were told by Health and Social Care Trusts that they have now put, I think, was it strengthened windows in some of their premises, that they've had to move services to other places, that staff have had to change their journeys to and from work, that women coming in presenting with miscarriage were nearly not coming into the centre to seek those access to services, where if they didn't, their life would have been at risk. So the current legislative framework does not work in these circumstances, because the harm must have occurred as well for enforcement and action to be taken. And we heard very clearly, I think it was from Claire Sugden during the last debate at second stage, that this bill seeks to be a preventative bill rather than seeking to address harm when harm has been done. And I think that this is critical in the circumstances that we're talking about, to ensure that the rights of someone accessing services are protected. And as the Human Rights Commission stated in their evidence session, it is too late to seek redress once access to healthcare has been impeded. Again, backing up what was brought up during second stage debate. So therefore it is important that legislation is capable of preventing harm from occurring in the first instance. And before going on to discuss the amendments individually, I would like to reiterate my condemnation at the threats that have been levelled at the officials in the department for merely doing their job and for working on this private member's bill. This is completely out of order, and I want those officials to know that they have my full support. I hope that this unfortunate incident might concentrate minds in this chamber to how serious
Excuse me,
the
Ms.
issue
Bailey.
is.
Members, if you wish to conduct conversations, I re-emphasise that outside is the place. Please. I beg your pardon, Mr. Clark. Sorry, you weren't. You were standing having a conversation. Okay. Ms Bailey, please continue.
Thank you, Deputy Speaker. Those engaging in the behaviour that we're trying to regulate are causing real harm and are traumatising women and pregnant people, staff and wider public. The behaviour is not low level. They are not there to help or support. They are there to bully, harass and intimidate someone from accessing healthcare safely and in confidence. The fact someone felt so threatened by this legislation that they deemed it acceptable to make a threat against officials goes a long way in highlighting the mindset of some of the people involved. Now I want to address the clauses specifically. So Clause 1, and on the advice of the OLC, I'm now proposing that Clause 1 no longer stand part of the bill. This clause provided an overview of the intention of the bill. However, it added no substantive legislative content and may be confusing while read with the provisions elsewhere in the bill, so it was deemed not necessary to include it, and I was happy to take that advice on board. The Amendment 1, I'm proposing this amendment just to tidy up Clause 2 of the bill, and I'm amending this to refer directly to the Abortion Northern Ireland No. 2 Regulations 2020. And this is important to ensure consistency with the language used in other legislation, and so that the provisions of this bill will relate directly to the commissioning of abortion services going forward. This amendment also ensures that the bill's remit is contained to only those premises where it is required, as a premise will only become a protected premise when notice is given to the Department of Health by an operator that it wishes to become one, rather than applying a blanket zone to all premises capable of becoming protected premises. While I know the will of the Department and the Committee and the number of key stakeholders was that the safe access zone would automatically apply rather than through some sort of process with the Department of Health, I believe that this amendment allows a zone to be established by way of this legislation without such a process being necessary, but in a way that makes it workable in practice. Members will note that on the Marshall list states satisfy conditions 2 and 3, but then goes on to outline condition 1 and 2. This is a processing error, and apologies. I've spoken with the Bills Office in relation to this, and it will be corrected in the printing of the bill following this stage, should the amendments pass. Amendment 3, Clause 3, sets out how certain premises that provide information, advice or counselling about abortion can also become protected premises. This amendment takes out the requirement for the Department of Health to make a determination that such a premise can be treated as protected premises, and instead replaces it with a provision that such premises can become protected premises by virtue of fulfilling the 3 conditions set out in this clause. The advice that I've received from the OLC is that this is preferable, as the conditions set out in the legislation are sufficient without the need for additional steps of the Department needing to make a determination and any additional issues created by that process. This is also commonplace in other bills where safe access zones are operable in other jurisdictions. Turning to Clause 5 in Amendment 4, a considerable number of submissions detailed the preference that a minimum distance for the extent of the zone to be detailed within the legislation. The Department of Health in particular had raised concerns with me over the difficulty in the original drafted provisions within the bill that would present for them. I recognise that including a minimum distance would simplify the process of designating a zone somewhat. However, I am also mindful of the evidence provided by the Human Rights Commission that previous jurisprudence on this issue is clear, that it is not the general principles of a zone that a court would determine on, but on the specifics of that zone. And for that reason, I am proposing that Clause 5, as originally drafted, does not stand part of the bill, and instead proposing a new Clause 5A in Amendment 4. In order to ensure that any zone established under this legislation is effective, but only as big as is necessary to meet the aim of the bill, this amendment would set a distance of 100 metres from each entrance and exit point of a protected premises, but with the option to extend this to a maximum of 250 at the request of an operator, should it be required due to the specific geographical setting of a particular premise in order to meet the objectives of the bill, which is to ensure safe access for protected persons as laid out in section 4 of the bill. And again, trying to address some issues that was raised about private operators. I think it was Mr Allister had raised that. I don't see anywhere in the Northern Ireland abortion order where private operators will be part of this bill. So I hope that lays rest of those concerns. The premises are stipulated under the Northern Ireland Abortion Order, the Regulations 2020, and they are the premises that will be in the context of this bill as well. Looking at clause 6, there's an important balance to be struck in section 6(2) of the bill, so that the identification of what constitutes an offence is flexible and inclusive enough to encompass the full range of behaviours that have the capability of causing harm to a protected person inside a safe access zone, while also giving enough certainty and clarity to those trying to enforce the law. And as the Northern Ireland Human Rights Commission spoke to at their evidence session, I don't think it is helpful to be too prescriptive in the legislation, as this could lead to a situation where we see attempts to go by the technical letter of the law and not to comply with the spirit of the provisions contained within the bill. As I've seen personally, and as the Health Committee heard throughout their evidence sessions on this bill, the type of conduct that can have the effect of impeding access to a sexual and reproductive health care centre is incredibly varied, and taken out of context may not always seem too problematic. But when it is targeted on an individual trying to access services, it absolutely can cause harm and distress, and ultimately impact on their right to access healthcare safely and in confidence. The health trusts were also clear about the cynical tactics employed by those engaging in this type of activity outside their clinics, where one person would harass a woman on her way into a clinic, another would harass her on the way out, in order to evade any potential consequences under the existing harassment laws, as has been mentioned. And as such, I am content that the wording of section 6(2) as it stands is sufficient to cover the full range of offending conduct, as it focuses on the intention and the potential effect of the behaviour, rather than detailing specific types of behaviour that could be worked around by those intent on intimidating women. There has been some concern raised in the written submissions that the level of fines for an offence may not be severe enough to act as a sufficient deterrent. And the primary aim of this bill is not to criminalise individuals, but to ensure safe access to services. And in my view, the creation of an offence, as well as powers given to the police under section 7, requires an individual to leave the zone, and associated offence for non-compliance will be sufficient to ensure the effectiveness of the zone. As such, I believe clause 6 is appropriate as a whole, and I am firm in my support that it stands part of the bill, but with a slight amendment. Amendment 5 removes subsection 4 of clause 6, and this was to take account of concerns raised by the PSNI around the difficulty this would pose for them in terms of trying to enforce the legislation. And I understand that in practice this would have little effect in terms of protections for anyone charged under legislation, as they would still be free to rely on any defence, any defence they wish, should they be facing any court proceedings, without the explicit reference to that in this bill. Clause 8 and Amendment 8. I am proposing that Clause 8, as originally drafted, doesn't stand part of the bill, but rather Amendment 8 will create a new Clause A. Most of what was detailed in Clause 8 is no longer required due to the more limited role for the Department of Health in establishing the zones in Clause 5A. The new Clause 8A sets out more clearly what role the Department of Health do have in publishing protected premises and safe access zones, And I know the issue of publication and making sure that people are made properly aware of a safe access zone was something that came up repeatedly during the committee's evidence sessions, during the debate today as well. And I hope that this new clause 8A will go some way to addressing that issue and those that were raised. It puts a clear obligation on the department, but importantly, it is not too prescriptive within the legislation and gives them flexibility to publish the zones in the manner that they deem appropriate. I'm cognizant of the fact that not every zone will be the same, and as such, how they're publicised may not also need to be the same. So this proposed amendment gives the department the space to come forward with their own policy on how best to meet those obligations within Clause 8A, and I believe that that's their preferred option, as I've already stated. Clause 9. A number of written submissions again expressed concern about Clause 9 of the bill, as they felt that some of the listed rights were in direct conflict with the rights of those accessing the services. And while this may be the case, any safe access zone established must be proportionate and reasonable restriction on human rights. Therefore, it's sensible that all engaged rights are considered when a zone is being established to ensure this balance is struck. And I am concerned that the Department of Health, however, has stated that it would not be an appropriate function of the department to carry out this assessment and that they would not have the competency to do so. And as the Human Rights Commission has pointed out in their written evidence, Section 6 of the Human Rights Act 1998 requires that public authorities do not act in a way that is incompatible with the ECHR. As such, the requirement to ensure that the actions of the department are compliant with human rights should be well established under current practice and how they operate at all levels, and should not be a particularly onerous requirement. While they are not the ultimate arbitrator on human rights issues, that does not preclude them or indeed lessen the responsibility to ensure that their actions are compatible with human rights under the 1998 Act, and is something that actually would be required, whether or not it was expressly stated within this bill. And indeed, the Northern Ireland Human Rights Commission expressly recommended this in the response that the department carry out a human rights impact assessment on a case-by-case basis when designating a zone. But that being said, I am now proposing to remove this section from the bill, as the amendments tabled today mean that the role of the department in establishing a zone has been greatly reduced, and as such the section is no longer required, given that the department do not have as many functions to exercise as was originally envisaged. The clear will of the department, the committee and the number of stakeholder key organisations that responded to the call for evidence was that the bill itself establishes a zone, and this is the one of the amendments required to tidy up the bill, given the changes that have been proposed to take this into account. Apologies, Speaker, I had a tooth removed yesterday and I'm feeling myself getting a bit stuttery, but I'm nearly done. Amendment 10. This, as a result of the proposal that Clause 9 does not stand part of the bill, a change is then also required in Clause 11 to remove mention to the Convention, as it no longer is required. Amendment 11. There has been some confusion in the written responses as to the meaning of Section 6(3) and to what extent this provision covers the recording of a protected person who is in a safe zone. The intention of this provision is that any recording, whether that be video, audio, photographic, taken of a protected person, while that protected person, thank you so much, excuse me. Thank you, Paula. The intention of this provision is that any recording, whether that be video, audio or photographic, taken of a protected person while that protected person is in a safe access zone, irrespective of the location of the person doing the recording, could be classified as an offence under the legislation. And it came through quite clearly during the committee stage of the bill that the committee wanted to make sure that this clause was capable of covering the full range of behaviours related to recording of protected persons. So I am proposing to provide a definition of recording in the interpretation clause of the bill at Section 11 in order to ensure that this is the case. Finally, on Amendment 12, again following the advice of the OLC, Amendment 12 seeks to provide the definition of what is meant by premises in this bill. It is necessitated, as it is envisaged, that the type of premises that could potentially require protection under the bill are quite varied, and it is important to ensure that safe access zone is effective regardless if the premise is a large hospital site or a floor of a shared building. So it is helpful to provide a clear direction in the bill what is meant by the term premises. This amendment also clarifies what is meant by attending a premises for the avoidance of any confusion in relation to the determination of a protected person. Speaker, all this bill seeks to do is to provide for safe access to abortion services in Northern Ireland that women currently do not have. And by moving people seeking to impede access 100 metres away from the entrances to and exits from premises does nothing to shut down any anti-abortion debate or activism. I hope that all members can understand the difference and that they can stand by women and staff rather than, as was alluded to earlier by Ms Erskine, rather than eyeing up votes. This is not about votes. This is about protection and safety measures that currently do not exist for access to free, safe, legal services in Northern Ireland. Thank you.
I thank the member, and I call Jim Allister to wind.
Thank you, Mr. Speaker. In briefly winding up this debate, I want to begin by refuting absolutely the undercurrent of suggestion that to oppose this bill is to embrace or to endorse abuse or attacks. One member even used the word violence against women. To oppose this bill is to say very clearly to this House the existing law is such that violence against women, abuse of women, is provided for in already stipulated legislation, and that this bill is a huge assault upon fundamental rights, namely the right of expression, to the very point where the sponsor of this bill is removing the least reference to protection of human rights, which was in the original Clause 9. So absolutely, I am not standing here, nor do I tolerate the suggestion for one moment that in opposing this bill I am endorsing in any way any of the things that have been described or ascribed to opponents of this bill. It was noticeable to me that the very significant step of introducing self-certification of exclusion zones and removing the role and the oversight and the scrutiny of that from the department, and to self-certify, to create a situation where the operators could self-certify these zones and self-certify their extension, that was attempted to be written off by the sponsor of the bill as tidying up. It's nothing like tidying up. It is a fundamental departure to say in legislation that areas from which members of the public can be excluded, it can be something decided on the whim of the operator within 150 metres, rather than, as it was in the original drafting of the bill, by the department. That is a mammoth step that has been taken in these amendments and is anything but a tidying up. I also noted in this, the contributions of those who are avid supporters of this bill, no one tackled the issue of why it's necessary to include in Clause 6 the wide ambit of criminalising influence. It's easy to talk about criminalising harassment and abuse and violence, of course, and they already are criminalised. But what this bill does in Clause 6 is to criminalise an influencer, anyone who stands in silent protest, saying nothing, absolutely saying nothing, is nonetheless criminalised if they are an influencer. Now, nobody who supports this bill has risen to their feet in this debate to justify that. And that's because it's unjustifiable. It is a step far too far in any legislation to say that if you try to influence someone in the public sphere, you are a criminal. Yes?
The member makes a very important point because we hear in relation to anybody who, and there is an undercurrent that anybody who is within a pro-life organisation or holds that view, that they are all antagonistic and that they are all shouting and hurling abuse outside certain premises. And we know that that is not always the case. So he makes a very important point in relation to that important aspect of this bill.
And if there are people shouting abuse and being violent and doing all the things that have been suggested, then arrest them. Arrest them for disorderly behaviour. Arrest them under the public order. Arrest them for various offences which already exist. But do not paint everyone who out of conscience has a protest to make and does it legitimately and does it respectably. Do not paint them as criminals. And that is what this bill does. And that is the primary offence of this bill to those who take a contrary view to the promoters of this bill about abortion. It is scandalous that this bill seeks to criminalise someone who legitimately holds a point of view but can never express it within a sanitised area. And all they are seeking to do is influence. Not to be violent, not to be abusive, just to influence and to stand for what they stand for. And yet, this bill is going to criminalise it. That is appalling. Yes?
Thank the member for giving way. I have direct experience of what's happening outside the doors of these centres. And when we're talking, and I think that I addressed it when I was addressing Clause 6, and how being too prescriptive then doesn't allow for taking into account what's happening on the streets. I mean, during my time working with the Mary Stopes Clinic, what was happening at the doors was not protest, Mr Allister. It was not protest. It was a deliberate campaign of harassment and intimidation to stop me doing my job and to stop women seeking access to that building, regardless of whether they were going to the 8th floor, the 9th floor, the 4th floor. I have been spat on, I have been physically assaulted, I have been splashed with holy water, I have reported to police, I have had it all caught on GoPros, I have caught it on CCTV cameras, and again, the police cannot deal with it under existing legislation because they say that it is insufficient, or else they can't gather enough evidence in order to secure a prosecution. So existing legislation is simply not enough. What is happening when the word influencing is put in there is there deliberately to capture the whole raft of behaviours and how that twists and turns in order to allow this deliberate campaign of harassment to continue. And that's what it seeks to do.
If the member was spat on, that was an assault. If the member was abused, that was a breach of Article 9 of the Public Order. If she was threatened, likewise, and subjected to threatening, insulting and abusive behaviour, those are offences. Also, the people doing that would be guilty of the offence of disorderly behaviour, and if it was a course of conduct, it would have been harassment. Now, there's a multiplicity of things in the criminal calendar which deal with that situation, but what the member wants to do is to push out the limits so that the person who does none of those things, who simply stands there, maybe with, as I quoted this morning, maybe with a quotation from the 6th commandment, thou shalt not kill, that person becomes a criminal because they are an influencer. They haven't spat on anyone, they haven't shouted at anyone, they haven't opened their mouth, they haven't been abusive, they've stood there. Now that person under this bill becomes a criminal, and that's where this bill goes far too far. And as if that wasn't bad enough, then within this bill it makes the offending absolute offences. Because one of the amendments is to take out Clause 6 4, which did provide a defence that if you didn't know or no reasonable way of knowing that the protected person was in a safe zone, then you hadn't committed an offence. Now, well, when I finish the point, so what the member is saying to this House, that she wants to create an absolute offence. Now, absolute offences are few and far between, and they're there for public policy reasons. One of them is it's an absolute offence to drive your car without insurance. Why? Because there's compulsion to compel people to have their car insured. Therefore, it doesn't matter. You can say, I forgot, my wife forgot, whatever. There's no defence. You are going to put into that category of absolute offence this business of criminalising somebody who's an influencer. Now, if that's not a step beyond what's rational and reasonable, I've no idea what is. Yes.
I think the member, you're much more well versed in legal and courtroom procedures than I, but a reasonable defence can be employed by anybody for any context, for any charges, in any courtroom, at any time. Is that right? It does not need to be stipulated in primary legislation that you can use reasonable defence as a defence.
If the member is finished, I don't recognise the phraseology of reasonable defence. Unless something specified in the relevant legislation, then either the offence was committed or not. Some legislation, and this is maybe what the member is thinking of, says someone without reasonable excuse. But your legislation doesn't say that. It doesn't say that someone commits an offence if without reasonable excuse. If it was there, that would be a different matter. But the member has created an offence which is an absolute offence. There is no reasonable excuse to being an influencer. You're a criminal. Absolute. So you know, the member need not rise to say, oh, you can always rely on reasonable excuse. You cannot, unless it's in the legislation. There's no legal defence of reasonable excuse. And the member should know that. And certainly, if she was considering that, would have known that. So we're in a situation where absolute offence has been created for somebody who's a mere influencer. And the question to this House is, how could that be conscionable? Yes?
The member for giving way, and just to go back to that point around how someone can stand and hold, as you say, a placard with scripture, and I go back to my original points. I get that it may not be seen under current legislation, and that's why we're here today. We wouldn't be having this debate if that was the case. But a person holding up a placard that claims that a woman going into that facility is a murderer, or a member of staff going into that facility is killing babies, how can that be deemed as acceptable? I mean, it's about the impact of that on all of those people, and that is why we're here today. So it's about making it. We're not taking that right away. We're asking people to move to somewhere else where you're not creating that much. It's harmful. It's plain and simple. It's harmful to the people impacted.
The member is saying that it is offensive, abusive, harmful to quote Holy Scripture, in particular, one of the 10 Commandments. And to simply say, thou shalt not kill, then that's an appalling position, I'd suggest, to be in. To say that you cannot bear witness to the fact that it is wrong to kill. Now, if you can't say thou shalt not kill, then the corollary of that is to say, well, you shouldn't offend anyone by telling them they shouldn't kill, and indeed carry on killing. That's, you know, if the offence said thou shalt, if the placard said thou shalt kill, would that have been offensive? But once it says thou shalt not kill, suddenly as an influencer you're a criminal. That's where this legislation is taking us, and that cannot be right. Yeah.
I actually didn't even mention Scripture as being the offensive part. I said that the offensive part is when people are blatantly called murderers, because that is the language that is used. Babies are killed in here. That is the language that is used. I fully respect people's right to freedom of speech around their religious views. But the reality is, as well, that not everybody using those facilities share the same religious views. So that's another debate for another day. But I think that that's very important, that we can't be using the view of one religious sect to influence others. So that's the point I'm making. It's the impact on people that we're talking about here.
Well, the member's making a different point. because when she first intervened, she talked about if you hold up something that says something offensive. If the member is talking about abuse being hurled and someone being called a murderer, if that is something which is threatening, abusive or insulting, it's already a criminal offence. I'm talking about the individual who does none of that, but who stands outside to demonstrate their opposition to abortion. I'm saying, why are you criminalising that influencer? Why do you think it's necessary to go beyond those who are abusing and threatening and insulting to incorporate those who are influencers? That's what this bill is doing, and that's the point that no one in this debate addressed whatsoever. And as I was making the point, it's now even more compounded by the fact that it's now an absolute offence. So this is the most draconian of legislation, and though this House will, I say to it that it shouldn't approve this legislation.
Okay, members. So, before I put the question, I do remind members that we have debated the opposition to Clause 1 stand part, tabled by Mr Allister and Ms Bailey, but the question will be put in the positive as usual. The question is the Clause 1 stand part of the bill. All those in favour say aye. Contrary, no. The noes have it. The noes have it. The noes have it. Amendment 1. Amendment 1 has already been debated, and I call Ms Claire Bailey to move formally Amendment 1. Move. Amendment proposed to Clause 2, page 1, line 8, leave out and insert words as printed on the marshal list. The question is that Amendment 1 be made. All those in favour say aye. Aye. Contrary, no. All those. Clear lobbies. The House will divide in 3 minutes. The question will be put in 3 minutes. Okay, members. Order, members. Resume your seats, please. Okay, members. Stuart Dixon, Paula Bradshaw are still members. Stuart Dixon. Mr. Dixon, you're still a member. Applies to you. Thank you very much. Thank you. Okay, members. The question is that Amendment 1 be agreed. All those in favour say aye. Aye. Contrary, no. No. Do we have the tellers? Okay, members. Tellers have been appointed as follows. Tellers for the ayes are Paula Bradshaw and Claire Sugden. Tellers for the noes, Jim Allister and Deborah Erskine. Remain all members of the requirement of social distancing while the division takes place. Clear the lobbies. The Assembly will divide ayes to my right and noes to my left. Secure the doors. Thank you. Members, okay. Members, clerk, please read the result.
86 members voted, 58 members voted aye, 28 members voted no. The motion is carried.
Motion is carried, members. The motion is carried. Unfasten the doors, please. Amendment number 2. I will not call amendment number 2 as it is mutually exclusive with amendment 1, which has been made. I want to close. Before I put the question, I remind members that we have debated the opposition to Clause 2, stand part, tabled by Mr Allister, but the question will be put in the positive as usual. The question is the Clause 2, as amended, stand part of the bill. All those in favour say aye. Aye. Contrary, no. Do we have tellers? Members have been advised by the party whips in accordance with Standing Order 113(5)(b) that there is agreement that we can dispense with the 3 minutes and move straight to the division. So, as I've said, I have now called for tellers. Do we have tellers? Okay, members, tellers have been appointed as follows. Tellers for the ayes, Paula Bradshaw and Claire Sugden. Tellers for the noes, Jim Allister and Deborah Erskine. Clear lobbies, semi will divide, ayes to my right and noes to my left. Secure the doors, please. Okay, members. Clerk, please read the result. Order, members, please.
86 members voted, 58 members voted aye, 28 members voted no. The motion is carried.
Motion is carried, members. The motion is carried. Unfasten the doors, please. Amendment 3 has already been debated, and I call Claire Bailey to move formally Amendment 3.
Moved.
Amendment proposed to Clause 3, page 2, line 3. Leave out and insert words as printed on the Marshall list. Question is that Amendment 3 be made. All those in favour say aye. Aye. Contrary, no. No. Do we have tellers? Okay, members. Tellers have been appointed as follows. Tellers for the ayes, Paula Bradshaw and Claire Sugden. Tellers for no, Jim Allister and Pam Cameron. Clear lobby. Assembly will divide. Ayes to my right, noes to my left. Secure the doors, please. Okay, members. Clerk, please read the result.
86 members voted, 58 members voted aye, 28 members voted no. The motion is carried.
Motion is carried, members. The motion is carried. Clause 3. Before I put the question, I remind members that we have debated the opposition to Clause 3 stand part, tabled by Mr Allister, but the question will be put in the positive as usual. Question is the Clause 3 as amended stand part of the bill. All those in favour say aye. Aye. Contrary, no. No. Do we have tellers? Do we have tellers? Thank you. Members' tellers have been appointed as follows. Tellers for the ayes are Paula Bradshaw and Claire Sugden. Tellers for the noes, Jim Allister and Pam Cameron. Clear lobbies. The Assembly will divide ayes to my right and noes to my left. Secure the doors, please. Okay, members. Clerk, please read the result.
86 members voted, 58 members voted aye, 28 members voted no. The motion is carried.
Motion is carried, members. Motion is carried. Unfasten the doors, please. No amendments have been tabled to Clause 4. Before I put the question, I remind members that we have debated the opposition to Clause 4 stand part, tabled by Jim Allister, but the question will be put in the positive as usual. The question is that Clause 4 stand part of the bill. All those in favour say aye. Aye. Contrary, no. Do we have tellers, please?
Colleagues who are opposing these amendments be interested in registering their opposition rather than going through the lobbies?
We have indications from two parties that they're prepared to do that with respect to a number of notified amendments. They've given us notice of that. Is that okay? Do we have tailors? Members, tellers have been appointed as follows. Tellers for the ayes are Colin McGrath and Claire Sugden. Tellers for the noes, Jim Allister and Pam Cameron. Clear lobby. Assembly will divide. Ayes to my right and noes to my left. Okay, members. Clerk, please read the result.
86 members voted, 58 members voted aye, 28 members voted no. The motion is carried.
Motion is carried, members. Motion is carried. On, fasten the doors, please. No amendments have been tabled to Clause 5. Before I put the question, I remind members that we have debated the opposition to Clause 5 stand part, tabled by Ms Bewley and Mr Allister, but the question will be put in the positive as usual. The question is the Clause 5 stand part of the bill. All those in favour say aye. Aye. Contrary, no. Do we have tellers? Do we have tellers? Members, just a wee bit of order, just a wee second. We're order, members. We think there may be a misunderstanding of what that last vote was, and I'm saying that because the people who spoke earlier on were talking about their position on this. So I prefer to take the vote again, and members are content. So no amendments have been tabled to Clause 5. Before I put the question, I remind members that we have debated the opposition to Clause 5 stand part, tabled by Ms Bailey and Mr Allister, but the question will be put in the positive as usual. The question is the Clause 5 stand part of the bill. All those in favour say aye. Contrary, no. Do the ayes have it? Do the ayes have it? No. Sorry, no. Sorry. Right, what time is it? Okay. The noes have it. The noes have it. The noes have it, just to be sure, Okay, members. Thank you. Amendment 4 has already been debated, and I call Claire Bailey to move formally Amendment 4.
Moved.
Amendment proposed after Clause 5, insert new clause, establishment of safe access zone. The question is that Amendment 4 be made and the new clause added to the bill. All those in favour say aye. Aye. Contrary, no. No. Do we have tellers? Do we have tellers? Okay, members. Tellers have been appointed as follows. Tellers for the ayes, Colin McGrath and Claire Sugden. Tellers for the noes, Jim Allister and Diane Dodds. Clear lobbies. Assembly will divide. Ayes to my right, noes to my left. Secure the doors, please. have a technical hitch with the previous vote, which we may or may not be able to resolve. The worst is that we'll only have to take the vote again if needs be. Okay, members, everything is resolved, thankfully. Clerk, please read the result.
86 members voted, 58 members voted aye, 28 members voted no. The motion is carried.
Motion is carried, members. Motion is carried on. Fasten the doors, please. Amendment 5 has already been debated, and I call Claire Bailey to move formally Amendment 5.
Moved.
Amendment proposed to Clause 6, page 3, line 4, leave out words as printed on the marshal list. Question is that Amendment 5 be made. All those in favour say aye. Aye. Contrary, no. No. Aye. Do we have tellers? Okay, members, tellers have been appointed as follows. Tellers for the ayes, Paula Bradshaw and Claire Sugden. Tellers for noes, Jim Allister and Deborah Erskine. To the lobby, assembly will divide, ayes to my right, noes to my left. Secure doors, please. Okay, members. Clerk, please read the result.
86 members voted, 58 members voted aye, 28 members voted no. The motion is carried.
Motion is carried, members. Unfasten the doors, please. Before I put the question, I remind members that we have debated the opposition to Clause 6 stand part, tabled by Mr Allister, but the question will be put in the positive as usual. The question is that Clause 6, as amended, stand part of the bill. All those in favour say aye. Aye. Contrary, no. No. Do we have tellers? Okay, members, tellers have been appointed as follows. Tellers for the ayes are Paula Bradshaw and Claire Sugden. Tellers for the noes, Tim Allister and Deborah Erskine. Clear lobbies. Assembly will divide. Ayes to my right, noes to my left. Clerk, please read the result.
86 members voted, 58 members voted aye, 28 members voted no. The motion is carried.
And the motion is carried. The motion is carried. On, fasten the doors, please. Clause 7. No amendments have been tabled to Clause 7. Before I put the question, I remind members that we have debated the opposition to Clause 7 stand part, tabled by Mr Allister, but the question will be put in the positive as usual. The question is that Clause 7 stand part of the bill. All those in favour say aye. Contrary, no. Do we have tellers? Okay, members, tellers have been appointed as follows. Tellers for the ayes, Colin McGrath and Claire Sugden. Tellers for the noes, Jim Allister and Pam Cameron. Clear the lobbies. Sammy will divide, ayes to my right, noes to my left. Okay, members. Order, members. Clerk, please read the result.
86 members voted, 58 members voted aye, 28 members voted no. The motion is carried.
The motion is carried, members. Unfasten the doors, please. Amendment 6 has already been debated. I call Mr Jim Allister to move formally Amendment 6.
Move.
Amendment proposed to Clause 8, page 3, line 26, leave out and insert words as printed on the Marshall list. The question is that Amendment 6 be made. All those in favour say aye.
Aye.
Contrary, no. No. Do we have tellers? Members, tellers have been appointed as follows. Tellers for the ayes, Jim Allister and Pam Cameron. Tellers for the noes, Colin McGrath and Claire Stoglan. The lobbies, Assembly will divide, ayes to my right, noes to my left. Secure the doors, please. Okay, members. Order, members, please. Clerk, please read the result.
86 members voted, 28 members voted aye, 58 members voted no. The motion is negatived.
The motion is negatived, members. The motion is negatived. On fact, the doors, please. Amendment 7 has already been debated, and I call Paula Bradshaw to move formally Amendment 7.
Not moved.
The motion is not moved. Motion is not moved. Before I put the question, I remind members that we have debated the opposition to Clause 8 stand part tabled by Ms Bailey and Jim Allister, but the question will be put in the positive as usual. The question is that Clause 8 as amendment stand part of the bill. All those in favour say aye. Contrary, no. The noes have it. The noes have it. Amendment 8 has already been debated, and I call Ms Claire Bailey to move formally Amendment 8.
Moved.
Amendment proposed after Clause 8 insert new clause, publication of list of protected premises and safe access zones. The question is that Amendment 8 be made and the new clause added to the bill. All those in favour say aye. Aye. Contrary, no. No. Do we have tellers? Okay, members. Tellers have been appointed as follows. Tellers for the ayes, Paula Bradshaw and Claire Sugden. Tellers for the noes, Jim Allister and Palm Cameron. To the lobbies, Assembly will divide. Ayes to my right, noes to my left. Secure the doors, please. Okay, members. Clerk, please read the result.
86 members voted, 58 members voted aye, 28 members voted no. The motion is carried.
Motion is carried, members. The motion is carried on. Fasten the doors, please. Amendment 9 has already been debated, and I call Ms Paula Bradshaw to move formally Amendment 9. Not moved. Thank you. No amendments have been tabled to Clause 9. Before I put the question, I remind members that we have debated the opposition to Clause 9 stand part, tabled by Ms Bailey and Mr Allister, but the question will be put in the positive as usual. The question is that Clause 9 stand part of the bill. All those in favour say aye. Contrary, no. The noes have it. The noes have it. Clause 10. No amendments have been tabled to Clause 10. Before I put the question, I remind members that we have debated the opposition to Clause 10 stand part, tabled by Mr Allister, but the question will be put in the positive as usual. The question is the Clause 10 stand part of the bill. All those in favour say aye. Contrary, no. Members, I note that the TUV and the DUP have both opposed the question. That party's opposition is now on the record. However, I think the ayes have it. The ayes have it. Thank you. The ayes have it. Amendment 10 has already been debated, and I call Ms Claire Bailey to move formally Amendment 10.
Moved.
Amendment proposed to Clause 11, page 4, line 17, leave out words as printed on the Marshall list. Question is that Amendment 10 be made. All those in favour say aye. Aye. Contrary, no. I note that the TV and DUP have opposed the question. That party's opposition is now on the record. Those parties' opposition is now on the record. However, I think the ayes have it. The ayes have it. The ayes have it. Thank you. Amendment 11 has already been debated, and I call Claire Bailey to move formally Amendment 11.
Moved.
Amendment proposed to Clause 11, page 4, line 21, insert words as printed on the Marshall list. The question is that Amendment 11 be made. All those in favour say aye. Aye. Contrary, no. I note that the TV and the DUP have opposed the question. Those parties' opposition is now on the record. However, I think the ayes have it. The ayes have it. The ayes have it. Thank you. Amendment 12 has already been debated, and I call Claire Bailey to move formally Amendment 12.
Moved.
Amendment proposed to Clause 11, page 4, line 21, insert words as printed on the Marshall list. The question is that Amendment 12 be made. All those in favour say aye. Aye. Contrary, no. I note that the TUV and the DUP have opposed the question. Those parties' opposition is now on the record. However, I think the ayes have it. The ayes have it. The ayes have it. Thank you. Clause 11. Before I put the question, I remind members that we have debated the opposition to Clause 11 stand part, tabled by Mr Allister, but the question will be put in the positive as usual. The question is that Clause 11 is amended stand part of the bill. All those in favour say aye. Contrary, no. I note that the TUV and the DUP have opposed the question. Those parties' opposition is now on the record. However, I think the ayes have it. The ayes have it. The ayes have it. Thank the members. No amendments have been tabled to Clause 12. Before I put the question, I remind members that we have debated the opposition to Clause 12 stand part, tabled by Mr Allister, but the question will be put in the positive as usual. The question is that Clause 12 stand part of the bill. All those in favour say aye. Contrary, no. I note that the TUV and the DUP have opposed the question. Those parties' opposition is now on the record. However, I think the ayes have it. The ayes have it. The ayes have it. Thank you. No amendments have been tabled to Clause 13, but before I put the question, I remind members that we have debated the opposition to Clause 13 stand part, tabled by Mr Allister, but the question will be put in the positive as usual. The question is the Clause 13 stand part of the bill. All those in favour say aye. Contrary, no. I note that the TUV and DUP have opposed the question. Those parties' opposition is now on the record. However, I think that the ayes have it. The ayes have it. The ayes have it. The question is that the long title be agreed. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. That concludes the consideration stage of the Abortion Services Safe Access Zones Bill. The bill stands referred to the Speaker. Thanks to all the members for their contribution and cooperation. Thank you. Members, take your ease for a moment or two.
Moved.
Time limits for the overall debate, but it has agreed a limit on individual contributions. The sponsor of the bill will have 20 minutes to move and 10 minutes to wind. The committee chair will have 15 minutes, and all other speakers will have up to 10 minutes. I call this level to open the debate on the bill.
Thank you, Deputy Speaker. I welcome the opportunity to move the Fair Employment School Teachers Bill. And from the outset, can I thank my Research Officer, Connie Egan, the Speaker's Office, the Assembly staff and all those at the Northern Ireland Assembly who support the progress of private members' legislation. The Fair Employment Act outlawed employment discrimination on the grounds of religious belief in Northern Ireland in 1976. Yet the Fair Employment and Treatment Northern Ireland Order continues to permit discrimination on the grounds of religious belief in the recruitment of teachers to this day. Almost all other workers in Northern Ireland can rely on legislation to protect them from discrimination on the grounds of their faith, except teachers. Under the Fair Employment and Treatment Northern Ireland Order, employers in Northern Ireland with 11 or more employees must register with the Equality Commission and monitor the composition of their workforce, but that doesn't apply to the teaching workforce. Recent research carried out by the UNESCO Education Centre at Ulster University suggests that only 2% of teachers in Catholic primary schools are from a Protestant background, and in primary schools with mainly Protestant pupils, only 7% of teachers are from a Catholic background. This can't be an acceptable status quo for teachers in Northern Ireland. The Equality Commission for Northern Ireland recommended the removal of the exception of teachers from the Fair Employment and Treatment Order for secondary level teachers in 2004 and early consideration to removing it for primary level, on the grounds that it is no longer acceptable to exclude the entire teaching workforce from fair employment legislation that covers all other occupations. It has also recommended that teachers be included in the monitoring and review requirements. Deputy Speaker, there is an increasingly clear consensus that teachers must be included in the Fair Employment and Treatment Northern Ireland Order and afforded the same legal protection from discrimination when seeking employment as anyone else in our society. The Fair Employment School Teachers Bill will give effect to these long-standing recommendations and presents this Assembly with the opportunity to remove the exception of teachers from the Fair Employment and Treatment Order. I am seeking the support and partnership of all parties in this Assembly to grasp this opportunity to give teachers fair employment protection in law. I acknowledge that time is now prohibitively short for reasons beyond my control, but I respectfully suggest that we should do all we can to pass this short bill to repeal the anachronistic exclusion of teachers from fair employment protection before the dissolution of this Assembly. For example, Deputy Speaker, it is my understanding that it may be technically possible for the Executive Office Committee to meet to agree the committee report for this bill, to complete committee stage of the bill, and to provide the Business Committee with the opportunity to schedule consideration, further consideration and final stages for the bill, which could potentially pass before the end of the mandate, particularly if there were no or only a minor amendments to the bill. I believe this is an approach worth considering, and I would be glad to speak with Executive Office Committee members after the debate about this proposal, and indeed I thank them for the conversations that we've already had. I would like to thank the Executive Office Committee for the proactive approach it is taking that might just make passage of the bill possible. I want to thank the Executive Office Committee Chairperson, Sinead McLaughlin, MLA, Deputy Chairperson, John Stewart, MLA, and all the committee members and committee staff for the written and oral evidence they have already taken on the Fair Employment School Teachers Bill, which has further demonstrated the extent of the support for the provisions of the bill. It's my understanding that in recent weeks, key stakeholders such as the Catholic Schools Trustee Service and the Catholic Council for Maintained Schools have confirmed support for the removal of the exception of teachers from the Fair Employment and Treatment Northern Ireland Order in oral evidence to the Executive Office Committee, stating clearly that the exception is no longer appropriate or required. It's also my understanding that the Transfers Representative Council, which represents the Church of Ireland, Presbyterian Church in Ireland and the Methodist Church in Ireland in all matters of education, has confirmed in written evidence to the Executive Office Committee that it supports equality of opportunity for teachers in recruitment and is opposed to unfair discrimination on the grounds of religious belief. This evidence is consistent with the response to my own public consultation on the bill, completed between April and June 2021, which found 94% of respondents to be in favour of removing the exception of teachers from the Fair Employment and Treatment Northern Ireland Order. In terms of stakeholder engagement, I've met with a number of teaching unions, all of which I understand support the proposal, including the NASUWT and the NAHT, which have done so publicly. I've met with the Council for Catholic Maintained Schools, which sought assurance that a Catholic ethos could be respected and maintained in any repeal of the exception of teachers in Fair Employment and Treatment Order, which I understand to be the case. and the Transfer Representatives Council, which reiterated its support for equality of opportunity in teacher recruitment and its opposition to unfair discrimination on the grounds of religion or belief, and gave a commitment to engage with this legislation at further stages. Mr Deputy Speaker, importantly, this Assembly has already adopted a position of undivided support for the urgent inclusion of teachers in the Fair Employment and Treatment Order in a motion debated in May 2021. I would also warn that the last time this Assembly attempted to pass this legislative reform was over 5 years ago. It's for all these reasons I'm convinced that there is broad public and political support for the provisions of the Fair Employment School Teachers Bill, and that this Assembly should do all we can to take this opportunity to pass this important legislation before the end of the Assembly mandate. Thank you.
I call John Stewart, the Deputy Chairperson for the Executive Office Committee.
Thank you, Deputy Speaker. I rise to speak on behalf of the Committee for the Executive Office. The Committee welcomes the opportunity to engage with this bill, and we acknowledge that it has been a long time in coming and that time is short. To that end, the Committee agreed to hear from the bill sponsor at the earliest opportunity, and further agreed to begin taking evidence in advance of the formal committee stage. The Committee issued a call for evidence on the 31st of January and has been hearing from key stakeholders through written and oral evidence to ensure that members were as informed as they could be by the time the formal committee stage came. We have already heard evidence from the Council for Catholic Maintained Schools, the Catholic Schools Trustee Service, the Integrated Education Fund, Ulster University, the Transferee Representatives Council and the Equality Commission. Our online consultation closes next week and we have over 330 responses to date. A significant proportion of these submissions have been from individual teachers, and these will be analysed and the Committee will consider the findings. We continue to receive written submissions, and I would like to record the Committee's thanks to the Committee of Education for sharing evidence that they have received on this matter. The issues that the bill aims to address are not new. The teacher exemption from fair employment provisions was debated in this chamber in May 2021, but this matter has been discussed for many years and the issues are well known. I do not want to go into the detail of the bill at this stage. The Committee intends to consider the evidence put before it objectively and conscientiously, and I have indicated earlier that much evidence has already been heard. I would like to thank the bill sponsor and all those who have contributed so far. It may be a short bill, but the implications can be more complex and even more give them more consideration in the future. We are close to the end of our deliberations, and thanks to the work already intended, we intend a relatively short formal committee stage. I will leave it there, and the Committee is committed to giving the bill its due airing, and we look forward to formally considering its provisions at committee stage. That concludes remarks as Deputy Chair, Deputy Speaker of the Committee. I'd like to make a few remarks in my role as an MLA for the Ulster Unionist Party. I want to thank the bill sponsor, the member for East Belfast, for bringing this forward. It is a mercilessly short piece of private members' legislation, but a vitally important one, ending an anomaly, for want of a better term, in fair employment law, allowing discrimination on the grounds of religious belief when appointing teachers. It has been long overdue for change, and the proposer will know that he and I have discussed this matter at length a number of times, and that both he and I and other members in this House during this mandate and previous ones have put question after question to the Executive Office and the First and Deputy First Minister, asking questions why it has taken this long. And I suppose if I could say that is my only frustration about this, that something so short that could have such a meaningful impact, not just in how teachers are appointed, but what it actually means to Northern Ireland and the changes that we will see as a result of that, has taken this long and couldn't be implemented in this mandate, given how easy, for want of a better term, it could have been to do that. And I don't want to wax lyrical, Deputy Speaker, just on the process and the history of this, but when we look back to 2013, the Ulster Unionist Party brought forward a motion at that time calling for fair employment law, allowing discrimination to be ended. There was an oral vote in this House at that time, and it was passed without any vocal opposition. And just a month later, Eugene O'Neill, of the Chief Executive of CCMS at the time, said, "Our Council finds the notion of discrimination on the grounds of one's religion abhorrent. It is on record as saying that, and they did not believe at the time in 2013 that there was a place for that exemption. That was 9 years ago. 3 years after that, our party with Sandra Overend and Danny Kennedy made amendments to clauses 26 and 27 of the Employment Bill in February 2016 that would do exactly what the member is trying to do today with this legislation. And that did pass, except for the use of a petition of concern that blocked it. And I find that regrettable. And that would have come into effect at the start of this mandate in 2017. But I suppose we are where we are, and it is just frustrating that this change couldn't have happened in this mandate. When we hear particularly about the overwhelming support for this change, there has been very little, if any, opposition to it. Potentially some concern raised about the impact that it might have to ethos, etc., but no vocal opposition at all. And in the hundreds of pieces of feedback to consultations, it has been overwhelmingly in support of that, and from every sector. And I want to pick up on the bill sponsor's point about whether we could provide accelerated passage through committee stage and through the final stages of this. I mean, that wouldn't be something that I would and others would ordinarily want to do, given the impact that that can have on legislation, but given the very tight scope and focus of this piece of private members' legislation and the impact it could have, I believe this is one example where that could be done. I'm pleased to say at the Executive Office Committee today that was agreed that we would write to the Business Office and the Speaker's Office and ask for that accelerated passage. So I think that would be, it would be a shame if in this mandate we couldn't get that through, given, like I say, just how tight that is. So, like I say, I want to thank the member for bringing it forward. I have nothing more to add, and I look forward to the rest of the members' contributions. Thank you, Deputy Speaker.
I call Pat Sheehan.
Cion Corla, and I welcome the opportunity to speak this important bill. As both previous speakers have alluded to, there's overwhelming support for this piece of legislation, and we have discovered, not just in the debate that took place in May last year, but in the bill sponsors' consultation and in our communications in the committee with stakeholders around this issue, there has been absolutely no opposition whatsoever. I think it was the previous speaker who mentioned the fact that there was some concern in CCMS that this move may in some way affect the ethos in Catholic schools. I don't agree with that. And in fact, CCMS and Bishop Donald McKeown himself, who's chair of the Catholic Trustees, made the point that the Catholic schools have never actually used this exemption when employing teachers, and forcefully made the point that they employ teachers from other faiths and from none as well in their schools. So it's important, and I suppose the most important part of this legislation, when this exemption is repealed, it will give the same protection to teachers under fair employment legislation as it does to every other worker in society. So that's really all I have to say on this. Cion Corla, there's overwhelming support in the House and outside this House, and I believe the public at large will be supportive of this measure as well. Like the Deputy Chair of the TEO Committee, and we have discussed this at committee earlier, that we would like to see this piece of legislation go its full way before the end of this mandate. Whether that is possible or not, I suppose will come down to the Speaker and the Business Committee as to whether that's possible or not. But given that it is such a short bill, we believe in the committee that that process should be expedited and we get this done and dusted before the end of the mandate.
I call Diane Dodds.
Thank you, Mr Deputy Speaker. Like others within the Chamber, I rise to give my support to the principles of this bill at its second reading. This has been a long-held manifesto commitment of the DUP, and we are very pleased to be able to support it. The policy objective of the bill is to remove the exception of teachers from fair employment treatment in Northern Ireland Order 1998, to ensure that schools are not permitted to use religious belief as a grounds on which to discriminate between candidates for teaching posts. In practice, we have a situation in Northern Ireland where employers of teachers do not have obligations to monitor the community composition of persons applying for jobs, of persons appointed to jobs, and of persons promoted to jobs, and that teachers are not able to bring complaints of religious discrimination relating to their recruitment. This exemption, while it is long held, is outdated in our society, and equal opportunity should be respected in all areas of life. However, while this is a short bill and there is a significant amount of support both within this House and in society for the objective of the bill, some of these issues are rarely as straightforward as they sometimes appear. The bill is silent on the issue of the Catholic certificate in religious education. This seems to me to be a significant omission and means that while discrimination is removed in one part, another anomaly remains. Ahead of the second stage reading, the Executive Office Committee has already, as has been said, been taking evidence on the bill and has received responses from a range of stakeholders across Northern Ireland. And I just want to put on record some of those responses to the House tonight. And the first response really that I want to refer to is the Northern Ireland Council for Integrated Education. And what they say in relation to the certificate is significant and important. And where they indicate that in this instance, the FETO exemption and the need to have the certificate in religious education to teach in a Catholic-maintained primary school and to teach religion in a Catholic post-primary school are linked. The Equality Commission has already also set this out in their arguments around the bill as well. In response to the committee, and I want to be clear with the House tonight, Bishop McCone and those from CCMS are and have accepted that this is an outdated part of fair employment legislation and should be scrapped. But in relation to the certificate, CCMS, and again I'm quoting from CCMS, the teacher's certificate in religious education is not simply a qualification that enables a teacher to prepare children for the sacraments. Rather, it is regarded as a genuine and necessary professional occupational requirement for those who aspire to be teachers in Catholic schools. I do think that this is an issue that is worthy of some scrutiny for the committee as we take the bill forward. And I too, like you, Vice Chair, would like to see the bill progress in this mandate, but I think we would do a disservice if we don't address the issues that have been presented to us within the bill. During the scrutiny stage of the bill, we have also had significant numbers of stakeholders who have indicated their support for the removal of the exemption, but their concern over the ethos of a faith-based education and the protections that may be needed to ensure that open conversations can be held on the ethos of a particular school. Again, I do think that this is worthy of scrutiny and of our attention. It should be noted that ethos of a school, it's not just a quirk of faith-based schools or the controlled sector. The integrated sector is also concerned about ethos, and in the Integrated Education Bill seeks to legislate for ethos of their schools, including the composition of boards of governors, etc. Equality screening needs to apply everywhere. So often when we look at legislation which seems relatively simple, straightforward change in the law, there can be unintended consequences. I am happy to support the bill. I think that this is an issue that is massively important for fairness in our society. and therefore the bill will have my support. But I would like to see us give due diligence to the concerns that have been expressed to the committee, and not to rush to the finish line without those concerns being addressed. And I think we owe that to the schools and the system in Northern Ireland, and the children who are educated there, and the parents who make choices about their children's education.
And can we have Daniel McCrossan onto our screens, please? And I call Daniel McCrossan.
Thank you, Mr. Deputy Speaker. I'm delighted to speak on this very important private member's bill brought forward by my colleague, Chris Little. The matter before us today is clear that the issue of the Fair Employment and Treatment Order, FETO as it's known, was once contentious in this chamber, with a multitude of opposing views brought forward by parties and individuals. I can see that since that things have changed. We're in a very different place, and it is apparent that the key stakeholders are mainly in broad agreement as to the way forward. In recent times, all sides have taken a measured, responsible and mature approach to what was once a very sensitive matter. It is also equally important in the context of today's considerations to recognise the dedication and hard work of all of our teachers and school staff. Their commitment to seeking the best for our children in all circumstances is beyond dispute, particularly given what we have just come through and continue to go through over the last number of years. From the outset, Mr. Deputy Speaker, the SDLP support this bill, as we believe that the legislative measure under question has long outlasted its necessity. The Fair Employment and Treatment Order was brought into being in 1998. It includes an exemption under Article 71, which is based on the 1976 legislation to address what was then perceived as a need to allow schools to use religious background or belief in deciding which teachers to employ. But since 1976, the social, political, cultural and religious landscape across Northern Ireland has changed substantially, and I do not believe that an exemption affording a legal right to discriminate against a teacher for employment on religious grounds is something that we need in 2022. Indeed, Mr. Deputy Speaker, it is undesirable that any teacher could be selected for the job simply based on their religion rather than employing the best candidate for the job. This exemption needs to be stripped out of legislation that would bring our laws up to date and rectify this issue. I do believe it is important in today's considerations to refer to the recent and very welcome statements by Bishop McEwen, representing Catholic Schools Trustee Service, and also Mr. Jerry Campbell, the Chief Executive of CCMS, on this matter. Both have declared their contentment with the move to remove this exemption, and I note too that Transfers Representative Council TRC has raised no objection, and the teachers' unions have expressed support for the bill also. I also welcome the fact that the Certificate in Religious Education continues to be the subject of an ongoing collaboration between St Mary's University and Stranmillis since 2019 to ensure that student teachers have access to the CRE as part of the bachelor's degree. This is a further indication of the emergence of a new and shared era in education, and across this place we share and call our home. Mr. Deputy Speaker, to conclude my remarks on today's considerations, the SDLP is happy to support the bill in the context that the entire landscape has changed since the introduction of the teaching exemption to equality legislation, and we believe that removing the veto measure will be conducive to having a properly shared future for everyone in the north of Ireland. And also, just on that, I want to commend Christopher Little on bringing this forward. It is important, and I do hope that he is given the space to ensure that we get this through. It is another very important piece of legislation which has the support of the SDLP, and I commend him, as others as well, in doing the work on this private member's bill. The same can be said for other members of the House, such as Pat Catney with the period products bill, and many others as well. This is very, very good legislation, and it has our support. Thank you, Mr. Deputy Speaker.
I call Kelly Armstrong.
Thank you, Mr. Deputy Speaker. Like others, I won't speak too long this afternoon. I think that the planets appear to have aligned on this bill. I would like to congratulate Christopher Little, MLA, for bringing the Fair Employment School Teachers Bill forward. It is certainly a short bill with only 4 clauses. It has been extremely well drafted. And as the bill sponsor has confirmed, this bill will ensure teachers are included in the Fair Employment and Treatment Order, giving all teachers the same protection as all other employees. But as we heard earlier from Mr Sheehan, this updates the practices relating to teachers in line with what's happening in schools today. I don't believe that any of our sectors have been using any discriminatory practices when employing teachers. So why should we still have in legislation something that is not currently being used? It is right and proper. Now, today is the 2nd of March. We have heard that there may well be an opportunity for the committee, the Executive Committee, to bring forward their report quickly. There's very little time left on this mandate, and it will be up to the Business Committee and the Speaker to decide whether there's room on the agenda going forward to the end of March for this bill to happen. I sincerely hope it does, because I would like to say on behalf of my family members and friends who are teachers, this gives them a protection that I had as an employee, that my employees have, and that many of us know for any employees, including, for instance, people who work in the Assembly. Why shouldn't teachers have that protection too? And I welcome absolutely Chris's work on this. I welcome the change of heart that has taken place with some of the organisations that have an interest. I believe that it's right and proper that we do have this change at this time, and I thank you very much.
I now call Chris Little, and you will have 10 minutes to conclude and wind up the debate.
Thank you very much, Deputy Speaker, and I would like to thank all members that have contributed to this concise debate and united response to the proposals that are being brought forward by the Fair Employment School Teachers Bill this evening. I'd like to thank the Executive Office Committee members, as I said earlier, for such a proactive response to this piece of legislation. Deputy Chairperson John Stewart, MLA, for setting out the already comprehensive approach that has been taken to the consultation and the call for evidence on the bill, with around 330 responses having been gathered already, which do appear to demonstrate further support for the bill. I note that that includes the most key stakeholder of all on this matter, individual teachers themselves. And I recognise the work of the Ulster Unionist Party undertaken on this issue in previous mandates, particularly in 2016, when a legislative amendment was previously attempted by Sandra Overend and Danny Kennedy, MLAs. And I do think that is a salutary warning to this Assembly as to how much time can pass between attempts to reform legislation, and that it is a warning to us that we do all we can to try and get it over the line on this occasion. I recognise and agree with John Stewart, MLA, that this pace would not ordinarily be the pace of legislative pathway that we would choose, but thank him for acknowledging that there is a tight scope and focus of the bill that should allow us to do all we can to pass the legislation. Thank Pat Sheehan, MLA, for his support for the bill and the acknowledgement of the overwhelming support that exists, and for the commitment that he has given to work together to see this legislation pass before the end of the mandate. Thank Diane Dodds, MLA, as well. We're in agreement, as is often the case in this Assembly, when it comes to matters, important matters of education in relation to fairness and equality. I welcome the DUP support for the principles of the bill and the acknowledgement that it is a DUP manifesto commitment. I note some of the concerns that Diane Dodds has raised. I genuinely believe that the Certificate for Religious Education can be considered in a different context than this particular bill, and I note Daniel McCrossan's acknowledgement of the work that has been undertaken between St Mary's and Stranmillis to improve the collaboration and the accessibility of the Certificate in Religious Education. There were respondents to the consultation on the Fair Employment and School Teachers Bill who did wish to see further reform in relation to the Certificate of Religious Education, but I have been clear from the outset of this particular bill that this would not be a vehicle to advance any further work in that regard. I also note concerns in relation to that were raised by Diane Dodds in relation to ethos. I think a lot of reassurance has been given in that regard, and I think the recent support for the provisions of the bill that have been clearly articulated by CCMS, for example, suggests that that reassurances have been received well. Thank Daniel McCrossan, MLA, for his support for the bill, and indeed for stating clearly that the exception of teachers from fair employment should be removed, and note his welcome of the recent evidence of CCMS in support of the bill, and as I mentioned previously, the positive collaboration between teacher training colleges on the Certificate of Religious Education. I thank him for recognising the work of a number of MLAs in progressing legislation in this House, and as has been a flavour of the debate, it is frustrating and quite hard to understand that a government department has not acted earlier to bring forward what is a simple piece of legislation, but that hasn't happened, and it has required us as private members to seek to move this legislation and to seek to build that consensus which does appear to quite clearly exist for the law to be passed in this manner. I thank my colleague, my Alliance Party colleague, Kelly Armstrong, MLA, for her contribution tonight and for the support and the advice that she has been throughout this private members process. She has worked extensively and courageously to show leadership on her own private members bill that she is progressing through this Assembly in relation to integrated education, and I thank her for the support that she has been in this significantly shorter piece of legislation, and for setting out her sincere hope that this legal protection for teachers can be passed in this Assembly mandate. Deputy Speaker, as I said in my opening remarks, I think this debate has further demonstrated the broad public and political support for the provisions of the Fair Employment School Teachers Bill, and I look forward to working with the Executive Office Committee members and indeed all MLAs to do our utmost to achieve the aim of this bill and to take this opportunity to pass this important legislation before the end of this Assembly mandate. Thank you.
Members, the question is that the second stage of the Fair Employment School Teachers Bill be agreed. All those in favour say aye. Contrary, no. The ayes have it. The ayes have it. Item 4 in the order paper is the adjournment. The question is that the Assembly do now adjourn. The Assembly is adjourned.
This is the Northern Ireland Assembly Plenary, Programme signed. This is the Northern Ireland Assembly Plenary, Programme signed. This is the Northern Ireland Assembly Plenary, Programme signed. This is the Northern Ireland Assembly Plenary, Programme signed. This is the Northern Ireland Assembly Plenary, Programme signed. This is the Northern Ireland Assembly Plenary, Programme signed. This is the Northern Ireland Assembly Plenary, Programme signed. This is the Northern Ireland Assembly Plenary, Programme signed. This is the Northern Ireland Assembly Plenary, Programme signed. This is the Northern Ireland Assembly Plenary, Programme signed. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme Sound. This is the Northern Ireland Assembly Plenary Programme